Good morning, everyone. My name is Nancy Grimm, and I am here to host a wonderful program on divorce and custody nuts and bolts. We have two wonderful speakers today with us. We have Jack Condliffe and Shannon Boisseau. Did I say that right, Shannon?
Yes, Nancy, thank you.
Before we begin, I want to go over a couple of housekeeping rules, and then I will introduce our speakers. What we plan to do today is have our speakers present until about 10:30, at which time we will take a break. We'll take a 15-minute break and resume at 10:45, at which time we will then pick up the program ending at 12:30. If you have any questions, please put them in the chat, and throughout the program, I will be monitoring those questions, and we will stop and answer them along the way. First of all, I'd like to introduce Jack Condliffe. Jack Condliffe joined Levin Gann as a principal in 2011. Prior to that time, he practiced many years with his wife until her retirement. His practice includes family law and adoption, complex personal injury cases, estate litigation, and appellate law. He's also served as an expert witness on family law and on legal fees. Mr. Condliffe has received numerous awards for his pro bono service, including in 2023, the Maryland Coalition Against Sexual Assault's Visionary Award. In 2020, the Judge Robert M. Bell Award from the Maryland State Bar Pro Bono Resource Center for pro bono service over a number of years. And in 2019, the Exceptional Service Award from the Judges of the United States District Court for the District of Maryland. He also received the prestigious Leadership Award from the Maryland Daily Record in 2013. An acknowledged leader in the law, Mr. Condliffe served as president of the board of the Pro Bono Resource Center for 2 years and was a board member for 10 years. In addition to serving as co-editor for Maryland's divorce and separation law, he has published numerous articles and has lectured widely. He has also been recognized as Maryland's super lawyer each year from 2010 to 2024. Mr. Condliffe has won many appellate cases that have changed Maryland law, including Bosman v. Bosman, abrogating spousal immunity, Arison v. Arison, standard for voluntary and mutual grounds of divorce, Volodarsky versus Tarachanskaya, establishing standard of evidence for abuse-based visitation restrictions, Jones v. Jones-Hurt, prohibiting the state courts from awarding military disability pensions to spouses and reversing 3 prior cases, and nearly 24 other published appellate decisions. Mr. Condliffe graduated from the Bethesda Chevy Chase High School, and well, I won't say the year, I'll just be quiet on that, and received his BS from the University of Oregon. After service in the Peace Corps and a successful career in business, he received his JD from the University of Maryland in 1991. Shannon Boisseau has been a part of Levin Gann since 2018, and she's been concentrating primarily on matters of family law and general litigation. Prior to joining Levin Gann, she served as a judicial law clerk to the Honorable Michael J. Finneter in the Circuit Court for Baltimore County, where she gained a unique perspective on the variety of complex matters as it relates to civil and domestic disputes, and identified invaluable strategies that have helped her refine her practice. She has had the pleasure and distinct honor to represent clients in front of Maryland's Supreme Court and the Appellate Court of Maryland on matters of first impression, and has been successful in establishing law as it pertains to Maryland's approach in determining the disposition of cryogenically frozen pre-embryos upon the dissolution of a party's marriage or partnership, and that is under the case of Jocelyn P. versus Joshua P. She graduated from Duquesne University with a BA in political science and a minor in psychology. Prior to and while attending law school, she was a part-time evening student. She was employed by the University of Maryland Baltimore Office of Research and Development, where she was responsible for negotiating industry-sponsored clinical trial and corporate contract agreements for the University of Maryland Schools of Medicine, Dentistry, and Pharmacy. She earned her Juris Doctorate degree from the University of Baltimore School of Law in 2017, graduating summa cum laude, and she was admitted to the Maryland Bar that same year. She has also been selected as a Super Lawyers Maryland Rising Star for each successive year since 2020. Quite the resumes. I would like to introduce to you our two speakers. Shannon, would you like to begin?
Thank you, Nancy, and thank you for the introduction. I am noticing now, notwithstanding my title on my little Zoom screen, my name again is Shannon Boisseau, and thank you so much for attending today. So I'd like to first start with basics of pleading, as Nancy had indicated. And first, we will go over kind of the basics of your complaint, your counter complaint.
Would you like
so
to
whether or not
complaint for modification?
Sure. I will actually have you bring that up. You can bring it up now, and I'll get to that in just a few minutes. But whether or not you are filing a complaint, which includes your initial complaint or a modification or a counter complaint, your pleading does need to allege sufficient facts to support your client's claim, whether that's the grounds for divorce or asserting a material change in circumstances for a modification, etc. Now, as of October 1st of this past year, 2023, Maryland has actually greatly simplified its grounds for absolute divorce and has completely done away with limited divorces. We will talk a little bit more on that later, I believe, today. As far as what you would include in your complaint, I think Jack and I are of the same basic philosophy here, in that we tend to set forth less information rather than more information. And you can see, I'm just kind of going through the complaint here. This is actually a complaint. This is actually a complaint for modification of custody. So the basics that you would need to set forth a complaint for modification is that you need to be sure that you assert a material change in circumstance. Now, a material change in circumstance, as I'm sure you are aware, is anything that is different than what was at the time of the last order, whether that was a judgment of divorce, a prior custody order. It has to be something of such significance that affects the child and the child's best interests to warrant some sort of change in either physical, legal custody, child support, etc. So again, those circumstances could not have been present at the time that the court last heard or the last order was entered for either custody, child support, etc. Now, if we go through this complaint here, and we'll just kind of scroll through a little bit, you'll see that there are definitely facts that we allege that are particular. They have to be, you need to assert facts that are particular enough, but you probably don't want to be as detailed as you otherwise would be in court. So you see here, well, actually, let me pull up the screen here because it's a little bit small. Bear with me one moment.
Shannon, let me know where you want me to be on this.
Sure. All right. So I am pulling it up here on my complaint, or on my screen, sorry. Okay, so just going to page 1 here. So you see that We allege that there has been a prior order, and that is on paragraph 1 and 2. We state what was in fact set forth in their order. That's paragraphs 2A through 2C. Then it is absolutely essential that you indicate that there has been a material change in circumstances which require a modification of that order. And in doing so, then you are, you'll need to set forth those facts and circumstances, again, that warrant that change. Specifically, then you will see our alleged allegations in paragraph 5, 6, and through the rest of the complaint. Nancy, I'm moving on to page 3. And then lastly, after you allege all of your facts and circumstances, you still need to make sure that you are setting forth the same requirements that are required in your initial complaint for custody, and that is a Family Law Article 9.5209. Specifically, you need to make sure that you have stated in your complaint the names and ages of all of the children or their dates of birth. And you need to make sure that you state the child's current address, who the child has lived with for the past 5 years, as well as where that child has lived. Whether your client has participated as a party, witness, or in any other capacity in any proceeding concerning the custody of the child. And if your client knows of any proceeding that could affect the current proceeding that you are filing for a modification, including any proceedings relating to domestic violence, protective orders, terminations of parental rights, and adoptions. Your statements or your client's statements are required to be under oath. It is good practice. Nancy, I am scrolling down to, if I can have you follow me to the last page of the complaint. It's good practice to have some sort of different section within the body of your complaint, usually at the end, whether it is like we have here, the Maryland Code 9.5209 affidavit, or whether you just title it affidavit, indicating that you're,
there you go.
Thanks, Jack. Indicating that your client does affirm under the penalties of perjury that the statements are made within personal knowledge, and having that signed by your client. That is absolutely required in any complaint for custody, any complaint for modification. If that information is missing or the affidavit is missing, the court can actually stay proceedings until that information is filed. So just be aware of that in any complaints or modifications that you do file. That also goes for any answers that you may be filing as well, if that information is not correct. And Nancy, if I can have you pull up the counter complaint. So we mentioned that the law has changed effective October 1st of 2023, like I mentioned, and we will discuss later. The grounds for divorce have been greatly simplified. There are now only 3 grounds for divorce, that being a 6-month separation, irreconcilable differences, as well as mutual consent. The mutual consent is still able to be filed if there is a child in common. Now, going back to what I had touched on previously with the complaint for modification, when we indicate that it is better to set forth less information than more information. You still need to set forth all of the information that is required to set forth your cause of action or your client's cause of action. But there are a number of reasons that you don't want to set forth too much detailed information. Number one, family law cases are extremely dynamic. This is a situation usually where facts change, could be daily, could be weekly, could be monthly. But in any event, you are likely to have either a different set of circumstances or a developing set of circumstances from the time that you file to the time that you actually get to trial. One particular case that Jack and I actually had recently when we filed, it was a pattern of continuing course of conduct basically through by father. So at the time that we filed, there were certain instances that we alleged triggered a material change in circumstance, but by the time that we got to trial, there were far more. So in that case, you want to be detailed, but you also want to make sure that your statements are broad enough to be able to encompass certain facts and circumstances that may be developing throughout that litigation process. You may also, you don't want to divulge too much information prematurely. A lot of information will be coming out through the discovery process, through interrogatories, through requests for production of documents. Perhaps you may take a deposition or your client's deposition may be taken. So it's best to not give the other side a leg up too early. The other thing to keep in mind is that you may not always be getting the most accurate version of facts from your client. Oftentimes in family law cases, they are extremely emotionally charged. And a lot of times through no fault of the client, their version of the facts is skewed in some regard by their emotional investment, whether that is a divorce, whether that is custody. So just that's something to bear in mind before you start alleging these highly fact-specific accusatory allegations, perhaps in your complaint. You want to make sure that you do your due diligence to make sure that those allegations are in fact truthful. Now, as far as the complaint, I'd like to just kind of go through that a little bit. You still need to make sure that this is a complaint for absolute divorce. This was filed prior to the change in the law, but generally the pleading requirements are still the same. But you do need to make sure that you allege that the parties were married on whatever date that they were, by either a civil or religious ceremony and where that ceremony took place. If the parties do have children, you need to make sure that you set forth that, again, their names, their ages, or their dates of birth. You also need to make sure that if there are children, again, you are setting forth those requirements of family law 9.5209 that we discussed previously. If the parties do not have children, that's also very important that you set forth. And of course, then we have the residency requirements. So generally now with the grounds for divorce, most grounds for divorce will in fact occur in the state of Maryland. So to the extent that is the case, there isn't necessarily that residency requirement where you have to be residing in the state prior to 6 months. For 6 months, excuse me. If the grounds for divorce do occur outside the state, then you need to make sure that you are setting forth that the parties have been a resident of the state of Maryland for over 6 months. Even still, it's just good practice to always keep that statement within your complaint. Now here you will see some general background allegations before setting forth the actual counts. Nancy, I'm on the bottom of page 2. You see count 1, adultery, which is no longer a grounds for divorce. but just for illustrative purposes. You want to make sure that if your party has a home, if they have a marital home, that you are setting forth the marital residence used as the principal residence for the parties and the children during their marriage. It's a good practice to state where each parties are employed or how they are employed, what their job title is, and whether or not your client may need alimony or a monetary award to get through these either next couple of months, or if it is an instance where it would be an indefinite alimony case. You need to make sure that you allege that as well, just setting forth the bases for your requests for relief. Now, talking about requests for relief, it is a good practice, and Nancy, if you can scroll down to page 3. It is a good practice to have your wherefore clause as comprehensive as possible. A good practice tip for this language would be, after you set forth all of your requests for relief, alimony, pendente lite, and permanently, absolute divorce, of course, you want to make sure that you request that if you are filing a complaint for divorce, or a change in custody if you are filing for a modification of custody. Notwithstanding, in the event that children are involved, whether it's an initial complaint or a complaint for custody, you want to make sure that you request legal and physical custody, and you want to make sure that you do that pendente lite and permanently, just reserving all of your requests for the court. So when you do get to a scheduling conference, you can set forth that, and you can ask for a pendente lite hearing. Even though they are not often awarded, we always ask for counsel fees. We always generally ask for determination of the value of marital property for the court to determine the ownership of all of that property. And of course, as all good practice, you want to request any and other further relief as the nature of this cause may require, something of that nature. I know a lot of practitioners have their own way of wording those requests, but something that encapsulates that. But as far as encapsulating any of the family law relief specifically, again, a good practice language tip would be to request the award of any and all relief to which the party is entitled pursuant to the family law article and or the Maryland rules. And that is actually in addition to the broad request for such other and further relief as may be necessary. And this is actually the language that I just had mentioned is directly from a recent decision handed down by the Appellate Court of Maryland. And that case is Lasco v. Lasco. And I believe that we will or have already circulated that case for you so that you can take a look at that. But that case actually indicates that that case actually regarded someone filing an answer and their request for relief that they filed in an answer. And we'll get to that in a little bit when we talk about the answer. Now, as far as we talked about residency requirements, but as far as where you can file, a divorce action can actually be filed in the county of residence of either of the parties. So if you have your client that resides in Baltimore County and the other party resides in Baltimore City, you have the option to file in either Baltimore City or Baltimore County. You could also file in the county that the defendant is regularly employed or has a place of business. Jack and I actually did this for a very particular reason in a case a few years ago, actually. Both parties were residents of Baltimore City, but the defendant husband was employed in Carroll County. We decided that it would be best to file in Carroll County. So we went ahead and we filed there. We talked about custody as setting forth all that required information. I do want to touch briefly, if no one has any questions specifically about pleading complaints modification. I would like to just briefly touch on motions to dismiss. Nancy, if I could have you bring up that document. And just bear with me while I pull it up on my screen. Now, motions to dismiss are very rare in family law proceedings. We almost never file them. And they're really only filed in the event of procedural defects. That is because there really is no basis to dismiss on the grounds of divorce anymore. One party really does have the ability to move the complaint forward, and a court will almost always defer to what is in the child's best interest if there is custody involved. However, if there is a party that boldly fails to state facts to support their claim, a motion to dismiss may be appropriate. And here, a colleague of ours actually filed a motion to dismiss based on the failure to set forth a material change in circumstance. So that is what we were talking about earlier. We indicate that there was no basis that the other parties set forth that did warrant finding of a material change in circumstance. Thus, the court should actually dismiss the case on its face, basically. Now, in this case, I believe this was filed by the mother, the motion to modify, and basically just stated that due to the age of the child, everything has become more expensive. Glasses were more expensive, the economy has increased, prices have increased. And based on that, that is not a material change in circumstances. It can't be something that just continues as a normal course of action. So it wasn't a circumstance in which the father stopped paying or got a new job, was making more money to be able to contribute more to child support. But because things just were getting more expensive, the mother decided that she was going to file a motion to modify. Not rising to the level of a material change in circumstance, the motion to dismiss was filed. And if I'm not mistaken, Jack, I do believe that it was actually granted.
No, it's still pending. Yeah, it's still waiting for a
pending.
ruling. Yeah, it's stuck in the city, which is behind because they're training all their staff on MDEC right now. If you could just go back to the reasons again for a second, I just want to point out one thing here. Just go up a little bit, please, Nancy. The one thing that a judge could say is a change in circumstances when she says no summer programs no assistance for summer programs have been given. You know, if a judge interpreted that as meaning summer programs in the nature of daycare, that alone could be grounds for a judge to deny the motion to dismiss. The real issue here is that, you know, we were trying to get the case out of Baltimore City because no one lived there anymore. So anyway, right now, nothing's happening. It's just sort of stuck.
Which is fairly common in Baltimore City currently, unfortunately. So I just wanted to touch on motions to dismiss very briefly. But as far as answers, so once a complaint for modification or initial complaint for divorce, custody, etc., has been filed, the other party is obviously required to file their answer, usually within 30 days, but if they are out of state, out of the country, 60 or 90 days. Each allegation in a party's answer, or excuse me, in a party's complaint must be answered, either admit, deny, sometimes admit in part, deny in part, and even other times we admit or deny and further state. Typically in any contested case, I will almost always file a counter complaint along with the answer. And again, filing those counter complaints are those basic requirements that we just went through. But as I had also mentioned previously, it is important to note that a party may actually request affirmative relief in their answer. So whether or not you are planning to file a complaint, or excuse me, a counter complaint, it is a good idea to nonetheless set forth your prayers for relief in your wherefore clause of your answer as well. So again, as broad as you possibly can, alimony, child support, custody, marital property award, anything else that may be relevant. Quadro, requests for retirement assets. In that case, again, is Lasco v. Lasco that allows a court to set forth the request for relief in their answer. The Appellate Court of Maryland specifically found that it is proper for a party to request a marital property award and any other relief in their answer. And they were citing to Maryland Rule 2323G. And that states if a claim for relief is placed in an answer, the trial court can still adjudicate that claim as if it had been properly designated as a countercomplaint, if the justice so requires, and usually, almost always, the justice so requires. In that case, the court actually determined that the wife's prayer for relief in her answer, requesting that the trial court determine and value the party's marital property and, quote, all relief to which she may be entitled pursuant to the family law article of the annotated code of Maryland, or the Maryland rules, was sufficient for the court to grant her a monetary award, even though it was not specifically requested in her husband's complaint, and even though it was not requested in wife's counter complaint. So please, please, please be sure to request all relief that you can in the answer. You really don't want to be in a position where you get to trial and you have all of your evidence for either alimony or a marital property award, and it has not been requested by either party, because some judges may allow you to orally amend your complaint, but some may not, and you may be out of luck. So again, best practice, make sure that you are requesting all affirmative relief that you can. Make sure that you have two of those catch-alls, the all further relief as justice may require, and the one that specifically requests all relief under the family law article and the Maryland rules.
Yeah, let me just
And
add.
of course,
Oh, sorry.
yeah.
Go ahead. I was just going to add here, this is really crucially important because, and it's why you see in all of your complaints, counter complaints, answers, it should be the complete laundry list of anything your client might even remotely be entitled to. Now, if they've been married 1 year and there's no marital property and you just want an uncontested divorce, you don't bother. If they both make the same incomes, you may not bother with an alimony claim. But, my philosophy is we have the laundry list, we start with everything. and we might delete some of the prayers for relief. And that's really sort of the best practice. Because my partner was in court in Harford County and there was something not in the complaint. The judge did allow it to be amended, allowed the other side to postpone and come back and finish the trial in about a month. And the reason that was done was because it was clear from all the discovery that our client was asking for that relief. It just wasn't in the complaint. And the judge said that the other side was on notice, so he was going to allow the amendment. But, you know, he could just as easily have said, nope, sorry, you're not getting that today. So just, it's easy to make a mistake there. I've done it a time. Everyone's done it a time or two. So thanks.
That's exactly right. And, you know, just to piggyback off of what Jack just said, sometimes you will be in a situation, and I say this from experience, where you plan to file a counter complaint, but for some reason, it just never gets filed. Either you're missing information from your client, the client never actually signs the counter complaint. In my particular case, you go to early mediation and you're hopeful that you can resolve it. And, you know, your client doesn't want to spend the money to, you know, is very conscious of fees and doesn't want to spend the money to draft a counter complaint, et cetera. And in that particular case, you know, in the back of my mind, looking back, hindsight's 2020, I only had a very minimal answer. So I basically said to deny wife's complaint for divorce and grant husband all other and further relief as may be necessary and appropriate, with the intention of filing a counter complaint, but that counter complaint did not get filed immediately. Fortunately, we then did get that filed, but you know, that's something that you always want to be careful of and make sure that you really are conscious of making sure and protecting your client's interest in both the answer and a counter complaint, just in the event that you never actually get to the counter. And again, you know, that relief to be requested, granting the divorce, joint physical custody, or sole physical custody, whatever is in, you know, your client's wishes, counsel fees, value of marital property, ownership of personal real property, you know, just making sure that you get everything that you possibly could assert for your client.
Shannon, I believe we have a couple of questions. Would you like me to
Sure,
entertain them now?
that would be a good time.
The first one is, do you agree that a parent now being able to care for the child is not a material change because it is not a change that affects the child? Is it a change that affects the parent?
I'm not sure that I understand the question fully, but I'll answer it in if the parent was unable or unwilling to previously care for the child, it may be a material change in circumstances based on the facts and circumstances. But if it is simply a party wanting to become more involved with the child, maybe not. Jack, I don't know if you have a different take on that.
So I was looking at that question. So I think if there was a medical problem, a disability, an untreated mental health issue that is now under control, I think that would be a material change in circumstance, because I think a child needs both parents, and that person's ability to now care for the child is a material change in circumstances. You know, if you had a parent that just sort of disappeared from the child's life and, you know, all of a sudden they're like, you know, I really want this child in my life, I'm not so sure about that. Although I have seen judges allow a parent to come in, particularly in third-party cases where, say, the grandparents have had custody for 3 or 4 or 5 years, and suddenly the parent comes back and says, oh, I'm ready to be a parent now. I have seen judges allow that, but I've never been convinced that that is a change in circumstances. So like Shannon said, it depends a little on the facts. I've had both those scenarios. And when you're dealing particularly with MVLS cases, I suspect there's going to be a higher proportion of both medical, disability, and mental health issues. Most of the cases I've done for MVLS have been grandparent custody or adoption, more often involving drug addiction of the parents than anything else, but sometimes other issues. So,
Thank you.
yep. And then there's a question, I think, under the chat too. It just says all relief under the family law article. Oh,
And the Maryland rules.
yeah, in the Maryland code. Okay.
So then other requirements as far as your complaints or your answers. You want to make sure that you are attaching your civil domestic case information report. Do not forget to include that. Whether you are filing a complaint or an answer, you need to be sure that your client has filed that document. It really is necessary for the court's scheduling purposes, and filing without this document, your submission is likely to be rejected. So just make sure that you keep that in mind. Of course, if alimony or child support is requested, either in a complaint or an answer, you need to be sure that the appropriate financial statement, whether that is a long or short form, and Jack will discuss that in more detail shortly, is also filed. And if you are filing your financial statement or a financial statement, you need to make sure that you are also filing a notice of restricted information. It will absolutely be rejected if you do not have that document. And something to keep in mind is the other party may actually move to dismiss your complaint if you are requesting either child support or alimony and you do not file your financial statement. Common courtesy to not do that, but if you have an instance where you need to get that complaint filed, that's perfectly fine. And do keep in mind that if you are the moving party and you do not plead either alimony or child support, but it is brought to issue by the other side's answer or counter complaint, you still need to file the appropriate financial statement. So just make sure you do not forget those additional requirements there. In terms of the things that also need to be filed with your initial complaint and or answer. Nancy, do we have any other questions that I could address? I think you're on mute. Nancy, I think you're on mute. Are there any other questions? Nancy, Jack, can you hear me okay? Or
Yeah, no, you're
Can you
fine. There
hear
we go.
me?
There's Nancy. Yeah.
okay.
Yeah. One of our participants indicated that when in Baltimore County, he was rejected for filing a notice of restricted information and was accepted only after correcting the submission to not include it. And then in the same county, I was rejected in another case for not filing the NOI. Perplexing.
So I can just say on marital settlement agreements, the different counties have different policies. Marital settlement agreements are not in the list of something that is automatically subject to restricted information. In Baltimore County, I've had different clerks do it differently. In Howard County, it's a strict policy. You cannot seal the marital settlement agreement. Personally, I think that that rule needs to be changed. I think there's so much confidential information regarding children and finances in there that it really ought to be restricted. But that's something that needs to go to the Rules Committee and have it changed. So, oh, it was an amended complaint. Okay, so I'm just reading what was the comment was. You know, sometimes the clerks just make mistakes. You know, I made a mistake on a pleading and then I refiled it. But if you don't tell the clerk in the comments section that you're correcting something, they might reject it because it's standalone and they don't realize they have to relate it back, especially if you do it more than a day later. So whenever you correct something with MDEC, you should always put in the comment section, corrected per deficiency notice, period, thank you, period. So that's
Yeah,
actually,
or the envelope number. I think I tend to
Right.
use the envelope number to make sure that, you know, anything that I'm filing to correct an earlier deficiency or something, that I include the original envelope number, just because it really does help the clerk's office out a little bit to make sure they know where things are going and what they are.
you know, and then it depends what's going on in the clerk's office. I mean, right after COVID, the clerk's office was filling something like 20 new positions or 20 staff
Mhm.
members. And, you know, there was quite a training curve. And they still allow the clerks to work from home who are managing some of the MDEC stuff also. And so you can't always reach them when there's something you want to talk about. Baltimore City, I can tell you because I've been down there a whole lot lately. On 3 different trials, the judges cannot wait for MDEC to go into place. They've heard so much good stuff about it from the other jurisdictions. The clerks, not so much. They're a little ambivalent, but they'll get there. So, but they're all in training. So if you think the city is slow, right now it's even slower than usual. I talked to 2 judges about it. At any given day, about 1/3 of the clerks are in training. So just be patient.
That's right. And even after implementation, I imagine that it'll still be slow and cumbersome for at least a couple of months.
Okay. We're a little bit ahead of schedule. Unless there are more questions, we can sort of switch to financial statements. So, okay, great. All right. Nancy, would you just bring up the filled out financial statement? Let me see which one that is. While she's doing that, so
Jack, was that the redacted version that you
yes, the
wanted?
redacted one, please. That's
Okay.
the filled out one. So I'm going to go through this redacted financial statement a little bit, and then we're going to circulate to all of you the 9202, the short form financial statement, and the long form financial statement that are fillable PDFs that come with the SassyCalc software. I have permission to circulate this from the owner of SassyCalc, who happens to be of counsel to this firm. You know, I don't have any financial interest in, you know, promoting SassyCalc, but obviously he does. But it is the software that the courts use, just so you know. It is kept up to date pursuant to the statute in terms of all the formulas that are used. You know, the problem with the public DHR website is you can't really save the information efficiently. And so if you're trying to do a bunch of different calculations, very hard to do. But there are some other vendors of the child support calculator. So, you know, SassyCalc is not the only one. It's just it's the one the courts use. So obviously, any child support case is required to have a financial statement filed with it pursuant to Rule 9202. If you fail to do so, it is either subject to a motion to dismiss or a motion for more definite statement. I've never had a judge grant it if you file it as a motion to dismiss. What they do is they deny the motion and grant the person leave to file it within 15 days, which usually a person does it. There are often times when I have filed a new case, if I'm representing the economically dependent spouse, especially when there are control issues where that person actually may not know their own financial information, in which case I literally file a blank form that says, plaintiff does not know the information, will supplement. So that's been a few times. particularly on cases where there's domestic violence, where the person has left the home. So for child support cases, it's just a formula. Sometimes I don't have all the detailed information, like for instance, health insurance information isn't always easily accessible in terms of what the child's cost is. You have to remember, you really have to get the rate sheet from the insurance company providing the health insurance, because if you have a family plan, it is the difference between the family plan and the plan for the parents that goes into that. In other words, it's only the children's cost that goes in there. Daycare expenses, that should be fairly easy to figure out. However, you also want to make sure you include summer camp. So sometimes what you have to do is figure out the daycare, add in the summer camp, and then come up with a monthly average, which requires a little bit of math. But that's a very straightforward form. It does have to be filed with a notice of restricted information. You're not going to necessarily see a lot of alimony cases or a lot of child support cases where this long form that I'm looking at now is required. So it's not going to be a huge part of the presentation today, but I did want to go through some points. Just because people are lower income does not mean that alimony isn't an issue. And I think we're going to be talking a little bit more about alimony on the second day. But I'll just make the point now that, my partner Angela Silverstein had a case from MVLS many years ago where the wife was disabled. The husband was making about $60,000 a year. There were very egregious facts causing the separation of the parties involving extreme sexual misconduct on the part of the father. It wasn't abuse, but it was pretty far out there. And Jack Hennigan, who is retired now, didn't lose a second awarding the wife the maximum alimony she could give, or rather that he could give, coupled with the limit on how much the wife could get because she was getting SSDI. So there is a cap on how much outside income you can get. And the judge awarded exactly that amount subject to the cap, because they do count the alimony as income for SSDI purposes. And back before they awarded fees for counsel fees, he asked my partner what her fees were, and she goes, "Your Honor, none. It was pro bono." These days you can get fees, which is something I'll discuss also. The key you'll see here on this first page, if you are doing the long form, which is either if the husband makes a lot of money, but the wife doesn't, you probably won't see that because most of those spouses, if they're not working, have zero income, can probably get a private attorney under those circumstances. But you do want to keep it in mind for alimony. I'm a maniac about having my first financial statements be very accurate. I know a lot of attorneys who just give it to the client, have them fill it out, and just file it as is. I do not do that. I always go through it with the client because it's definitely a subject of cross-examination if it actually becomes relevant at trial. Now, you can always file an amended one. You can file any amended financial statement 10 days or more before trial, although sometimes in the scheduling order, you have to do it earlier. But, you can forget. I've forgotten a time or two. There are ways around it if you forget in terms of getting the evidence into court. And you'll see here the allocation of 1/3 of the housing expenses for the spouse. I think it was the husband in this case, and 2/3 for the children. I don't usually do 1/3, 2/3. I typically do 50-50. I think 1/3, 2/3 is a little aggressive, but I don't think it was wrong to do it. I just don't think a judge will consider that. This was actually done by an opposing attorney, and I liked it so much I've used it for this seminar. It's one of my best financial statement forms I've ever seen. Really, really well done, really specific. If you're not good at math, you should at least learn how for this form. Certain expenses are not so easy to figure out. For example, you don't know what future health insurance will be for your client, which they might need after the divorce. Certain expenses like repairs at the bottom here are guesswork. If we can just scroll down a little bit, maybe to the next page. Keep going, go down to C, I think. Yeah. Other household necessities, people usually can figure that out these days, if they're paying with a card or with the food stamp card. And that number, I mean, when I started out practicing, my grocery bill for a big family was like $100 a week. My grocery bill now, just for my wife and me, is about $170 a week, including all household supplies, so it's gone way, way, way up in the last 5 years in particular. Standards. So the question is, do I ever use national standards? I don't. What I do is I have my client footnote every calculation that is either a guess or an estimate. And the reason that that is so important is because a year later, when you're going over this with your client and getting ready for trial, you're not going to remember, and they're not going to remember how they came up with any of the numbers except things that were obvious averages from, utilities, car insurance. Those are easy. But the things like therapist and counselor, they change all the time. Eyeglasses, that can be a guess. You might not need new glasses for like 3 years. You might need them every year. Dental and orthodontia, there's the twice a year expense, but not the other. This question about, can I put down future financial anticipated information? Yeah, I do that all the time. I make sure I footnote it because, the judge is going to look at it and, your client may get the question, well, you put that down, you weren't really paying that expense, were you? And they may get flustered. But if you have a footnote, you remember what you did and you prep them and they're going to go, yeah, I put it down because as soon as the divorce is over, I'm going to have that expense. Or these days, because a physical separation of where you live is no longer required for either for irreconcilable differences and possibly even for 6-month separation based on the new statute, the person who moves out may not know what their rent and other household expenses are going to be. So you absolutely can do that. Typically, I do an amended form closer to trial and include all that information, but it really is case dependent. So that's a great question. So that's something I learned early on when I kind of got beat up on it in the trial because I hadn't really done that properly.
Jack, I have another question if you'd want to entertain.
Yeah,
this
please.
one.
Yep.
For the mortgage, did you divide the total by 3 for the parent and the 2 children and allocate 1/3 to the parent and 2/3 to the children?
Well, yes, that's what's done on this form. That's exactly right.
Okay.
And I usually do 50-50. Maybe if there's 4 or more kids, I might do 1/3, 2/3, but you want to make a reasonable guess as to how to allocate it. I can't really think I've very often done anything other than 50-50, but that's just my practice. And then the judge is just going to do whatever they want anyway. So, they all, if they have any experience, maybe not the new judges, but, now you don't see a lot of alimony cases in Baltimore City, but in Montgomery County, Frederick County, Howard, Baltimore County, Anne Arundel County, you see it all the time. And the judges usually have a lot of experience going through these long-form financial statements, and they all have their own different practices. For example, if you go down here, let's go to F or G, gifts. Yeah, here you go. Vacations, $930 a month, which is basically about $10,000 a year, right? And, that's either sometimes a future expense or it's a real expense. I mean, and some families don't take any vacations. My wife's family, they never took vacations. My wife didn't really go on quote unquote vacations with the kids, my stepkids and our kids together until I married her, because my family always went on vacations together as a family. So, it depends. And that number can get very high if you have higher income cases, which, I know we're talking about MVLS cases right now, but I suspect some of you have other cases. But this section F, this is an area where judges may eliminate a lot of stuff you've written down, like $150 a month for an allowance. Well, maybe if you've got 3 teenagers, but otherwise that seems a little high to me. You know, cable TV, that's actually pretty low. I don't know how old this sheet is. These days, that expense would probably be around $200 a month. Dining out, $350. That's a little on the high side. But, you know, if you go out once a week as a family every Friday night, and you always did that, put it in. If you keep going down, you know, the gifts, religious contributions, let's go to H. This is another area. Courts constantly cut these down if you've been a little too greedy in what you write down. Most judges, for example, I've often represented, so, you know, if you represent people in certain religions, there's mandatory tithing, or sometimes you see voluntary tithing. It's mandatory tithing in a number of religions of 10% of your income, and they take it very seriously. I've rarely seen judges include tithing in someone's expenses in an alimony case. They usually knock that out right off the bat. And I've seen much higher holiday gift, birthday gifts to others, but these are actually very reasonable numbers here. This lawyer did a great job. And then down to attorney's fees, $5,300 a month on 40,000 of attorney's fees. Absolutely include that. And I'll often do it as an estimate as if the case is going to go to trial. And then they've deducted that they're paying alimony or child support from a prior order, which is also, by the way, something that goes into the short form financial statement. Sorry, something that goes into the child support calculation. So anyway, you know, I spend a lot of time on these because I don't want to have my client cross-examined, and I footnote everything that's not obvious. I usually don't bother filling out the federal and all that information. I'll usually just put in the gross and net. I just don't feel like taking the time to do the math. And if you put in both, it's not really that important. You know, yeah, they put in 40% estimate, 533, other income. You know, you have to ask your client, and I'm a straight shooter. If my client tells me that they're moonlighting and getting paid cash, I put it in and they say, well, but, you know, I can just stop doing that. You tell them, yes, you can. But, you know, I recently had a case where the wife had a second job. She had custody. And until the bitter end, the attorney kept telling me, well, she's only working that second job because, you know, the husband isn't paying enough in child support, or he doesn't pay her enough money for her to support the kids. And the law is clear. If you're working a second job, it goes into the child support calculation. And, you know, there's a famous Montgomery County case where it was included and the guy complained bitterly. And the courts were like, you know, if you stop working that second job, you can come back for a modification. You know, and you have to explain it to the client because the client may stop working that second job. Now, the other attorney is going to come in and say, well, right up to the time of the separation, you know, you were working a second job and making X, weren't you? And, you know, the fact of the matter is, you know, judges will go, okay, fine, I got it, but the law can't require them to work a second job. And they haven't been, you know, for 8 months now. And I can't make them, and I'm not going to include that income. I don't think a judge can impute income from a second job under the statute. So anyway, and that's really the basics of all this. Let me just look and see what else is in my notes. So I always ask the client, how good are they at math? And, you know, this is an area where I probably do more hand-holding on the financial statement than I do interviewing my client about the facts leading up to the separation and the divorce. Because I just think it's crucially important to try and get it right out of the starting gate, no matter what. You really, really want to do that. And I think I said this before, but it's basically set monthly expenses or average from something you pay quarterly, semi-annually, And then the other two categories I use are estimates. And then sometimes there's just a category for wild ass guess, right? So, you just don't know yet what your bill is going to be on some item, like repairs if you buy a new house. You have just absolutely no clue. Or you may look into getting a house warranty if it's a new enough house, in which case you can maybe make some guess. But when you're doing that financial statement into the future, you just got to take a stab at it sometimes. All right. What else? Those are the basics. So you really have to keep in mind your clients really are not very good at this. So let's just go through the short form for a second. This really doesn't take a lot of work. I will comment, just stop here for a second, where it has DOB and age. A lot of people are taking the position these days not to put the child's birth date into anything that goes into the court record, whether or not it's restricted information, just because of, cyber theft issues, even for a minor child. And these days in federal court, you're not allowed to put a child's name in any pleading or a birth date at all. If you have to mention a child's name in any federal court case, not too many, you just have to use initials. And if you take a look at a lot of appellate decisions these days, the court is more and more using either first name initial, like the case that Shannon just won on custody of embryos, or custody cases with really egregious facts. They'll use the initials of the parents. The first time I saw that extensive, it's always the case in Senate cases, but the first time I saw that in the family law case, where they just used initials, was an opinion of Judge Nazarian right before COVID, where one of the key witnesses was the third intimate partner in a long-term relationship, who, when all three broke up, testified for one. And, he didn't get into who people were in that case, but it was highly relevant to the appellate opinion. So he was sort of cautious about that. And that's becoming more and more and more common. And I'm not so sure, and a lot of states do it, and I'm not so sure you're not going to see a rule change in the next 5 years mandating that for appellate cases and even for circuit court cases. So, all right, let's just go down here. Most of us has probably filled out a bunch of these, but monthly income before taxes, child support you're paying for another child, any alimony payments, and then go down here. School and transportation expenses, extraordinary monthly medical, which of course the statute has been changed a lot. When I started practicing, it had to average $100 a month or more. And now I can't remember, I think it's either $250 or $350. The other thing to keep in mind with child support, I'm just going to touch on it very briefly now, when we talk about child support at the next session, is for a lot of your clients, and I'd forgotten about this while we were prepping, and let me just see if we have this in here. Right, for a lot of your clients, the new statute where the court won't order child support at certain low levels of income is going to be crucially important in your representation. And if you're just doing one or two pro bono cases, and most of your cases, both people or there's sufficient income, you really have to study that part of the new child support statute, which cuts a huge break to lower income people, disabled people who really have very limited income, both in terms of not counting certain income for child support, but also guaranteeing what's called a minimum income where child support doesn't have to be paid. So when you're doing these MVLS cases, you really have to take a look at that. And frankly, since we're coming back in 3 weeks for the second session, we'll probably add a little bit to the agenda on that, because I was just remembering that. All right, any more questions about this? I see something in the Q&A section. So
I don't think
no,
it's,
yeah, it was 2 people asking the same question, or so.
yes.
Yeah, okay. All right, good. Any other questions about the financial statement? So let me just look and see what's next. Why don't I go ahead? We're going to start talking about mediation and settlement agreements. And one of the things I will circulate that I didn't provide to Nancy today is I have a template which has all kinds of different sections for separation agreements. So first, let me talk about mediation. So pretty much every court in this state requires mediation for custody. How they do it varies wildly between the different counties. Baltimore County, they have staff mediators in the Family Services Office who I consider to be really very, very good at their jobs. The current people are sort of newer. For the first 25 years of my practice, it was sort of the same old faces for a long time, many years of experience. A lot of them retired recently, including the head of mediation, but I still consider them to be very good at what they do. Mediators in Baltimore City, completely different. So they have contract mediators, and my wife is one of them, who only deal with custody. They mediate in pairs. It used to be a program run by Shepherd Pratt. Now the court runs it themselves. The first session of mediation for both the county and the city is absolutely mandatory. In the county, it's scheduled at the time of the settlement conference. In the city, you get a court order, and then the mediators reach out and contact you. Their mediation in the county, I think, can be done by Zoom typically. I don't know if they do in person at this point. They've all been Zoom lately, so I still think they're all Zoom. In the city, they're absolutely all Zoom because the mediators are all over the place. My wife's and in the city, it's always two mediators, a man and a woman, which in many jurisdictions is a standard practice for custody mediation. And I know that the partner my wife works with is in Annapolis, and we're in Baltimore County. So, no one drives to the courthouse anymore for this mediation. Mediation is never reported to the court. Howard County has their own mediation program. Carroll County, they basically kind of what's that called? The court volunteers the family law attorneys in Carroll County to be mediators. Pretty much, if you're doing family law in Carroll County, the judges are going to sort of say, oh, you have to get added to the list of our volunteer mediators, and no one says no. And I find the mediation in Carroll County a little bit hit and miss because, everyone's sort of trained, but the quality varies a lot depending on who the mediator is. Up in Harford County, the mediators are pretty highly skilled, and they will do a very full report. They have this weird rule up there that while the mediator will come into court at what they call a sort of mediation conference, and they will make their report, they sort of have this rule: you're not supposed to cross-examine the mediator or call them to testify at trial. I don't think that rule is permissible. I'm just waiting for someone to challenge it and have it go up in appeal. And, a couple of counties have had their wrists slapped, like Cecil County did that. They had their wrists slapped in a published opinion many, many, many years ago about doing that. And then in Baltimore County, they will not allow they will not give you a copy of any of the materials that the custody investigators have obtained. So, different rules, different counties. I am a huge fan of mediation. There is almost no case, no matter what the facts are, where I will not agree to mediation. And because most mediators will sort of do shuttle diplomacy mediation, I will usually, as long as both sides have counsel, agree to mediation, even when there's a history of domestic violence. But you really do have to be careful about that and make sure that there's equal bargaining power, usually accomplished by having attorneys on both sides. But if, a pro se party is a victim of domestic violence, that is not an appropriate case for mediation under any circumstances. So I would never do that. If there are allegations of child abuse, I probably wouldn't do mediation. I'm also a huge fan of private mediation, but it can be quite costly. You're probably not going to see that in MVLS cases. But if you have a really complicated case, you might be able to rope one of the senior judges into doing a case pro bono if it really, really, really needs more complex mediation than the courts can provide. Because the courts usually provide only 1 or 2 hours of mediation for you, and private mediation can go a lot longer. All right, any questions about mediation? So,
Jack, we can break now if you would like.
yeah, because the next topic is settlement agreements, and while that's going on, I'll actually send my template for you to circulate, Nancy.
Okay,
And,
that
I may
sounds
have
good.
you bring that up.
I think what we will do, and thank you both so far for such an interesting topic. What I think what we'll do now is it's about 20 after 10. Let's take let's see, a 15-minute break. Is that okay with everyone? And we'll be back at, let me just check my time here. Yeah, let's come back at 10:35 and we'll reconvene at that time. I do want to tell everyone because I have been getting some in the chat, some questions. I will be distributing the video and all the materials to you after the session, so you will have them. I will also be posting them on the Judicare listserv as well for those of you who are members. Rest assured you will have these documents. I also want to make sure before I forget why I'm telling you now is that when you signed up for this program, you signed up for both programs. So you will be using the same link on April the 24th when you sign on for the second half of this series. So with that being said, let's take a 15-minute break. I'll see you all back here at 10:35. Welcome back, everyone. Before we begin, I just realized I was neglectful in mentioning Shannon's role in the Maryland Divorce and Separation Law publication. She wrote the section on custody and probably some other things as well. And I neglected to say that. And so we're so happy to have the experts here to talk to us about this topic. Jack, would you like to continue?
Yeah, so I just emailed you, Nancy, the template I use for separation agreements.
Yes, I did
Can
see
you
that.
maybe bring that up on the screen?
I will do that.
right.
Let's see here. All right, I'm just going to share my screen and we'll be ready to roll.
Okay. There we go.
Okay, there you go.
Okay, so I think as everyone on this call probably knows, somewhere between, I don't know, 95 and 98% or more of all cases settle before you get to trial, you know, either at mediation or at the courthouse steps. Or I had one 2 weeks ago, literally in the middle of trial after after there was some cross-examination. And what I've got on the screen and what's going to be circulated to you is basically a template that I have sort of had for pretty much 30 years now, that I update about every 2 years, and those rare occasions where I feel like I've got an extra hour or two to work on it. And it pretty much covers every eventuality for a marital settlement agreement, although I have not updated the language on, you know, mutual consent or voluntary separation since the new law went into effect. Just a little bit of history on this is interesting, because these forms, everyone has probably seen almost all the boilerplate language in here and a lot of the substantive language. And it actually comes from a publication, and I'm not even sure it's in print anymore, that was simply Maryland Divorce Forms written by Ann Turnbull before I was a lawyer, so well over 30 years ago, and it's circulated over time to almost every family law attorney in the state, and almost everyone uses a lot of the same language. I have made some changes to it over the years. I've seen other lawyers. I actually have a provision I've stolen some of the provisions here I've stolen from other lawyers because I liked the way they wrote something. But basically, this is the basic form that, in my experience, almost all attorneys use. And you're going to see different options in here. For example, for income tax returns, there are different options in here for marital debt, because Maryland doesn't, unlike other states, does not recognize marital debt other than as a factor in marital property. Other states allow the allocation of marital debt along with the allocation of marital property, even if the creditors don't allow you to change who owes on the marital debt. So the you know, the form is obviously really important. I'm going to just scroll down it a little bit and touch on some of the pertinent points in these agreements. Because this applies whether you've got, you know, people who have $500 million in assets or people who have no assets whatsoever. If you're doing a settlement, there are parts of the separation agreement you're going to want to use, even with the pro se party on the other side. So terms of separation, that's fairly unimportant. You can go down to item 2, that boilerplate. You know, this isn't more important for the client than it is legally. You know, people are always asking me, you know, can I date, or what happens if I have sex? You know, can I do that now that we're separated? And the answer is almost always yes. Yeah, technically it's still adultery. That's not a grounds for divorce anymore. It's still a factor. It's probably not even a factor anymore in alimony or marital property because the factor concerning fault is things that led up to the separation of the parties, not things that happened after the separation of the parties. So I actually don't think that post-separation adultery is even relevant for any purpose anymore under the law. And that's probably something important in the advice you give clients when they ask you those questions about intimate relations with people, not their spouse, before they're divorced. But this is the language that sort of says that we're not going to bother each other, and we know we're going about our separate lives. Rights incident, rights of surviving spouse. This is the general release language. This is pretty crucially important because basically anything that's not mentioned in an agreement is a walkaway. So the language right there, each of the parties releases all claims and demands of any kind nature against the other party. And this exact language probably appears in virtually every separation agreement that's been reported in court, for at least the last 30 years since I've been practicing, and probably more like 50. And the same thing with the next section, release of claims under the Marital Property Act, except as otherwise provided herein. And I think those sections 3 and 4 are pretty much mandatory in any divorce case, even if there are no assets. There's just absolutely no reason not to have that in the agreement. Okay. Now you get into different custody provisions, and these will get edited. Excuse me a second. Sorry, these will get edited a lot. I don't think it's in here, but I have very specific templates for sole custody. When I am doing a shared custody schedule, like a 2552. So 2552, that's where one party has Monday, Wednesday overnight. The other party has Wednesday, Thursday overnight. And then you alternate Friday, Saturday, Sunday overnight. I actually put in a 2-week or a 4-week schedule specifying who has what nights. So you're just literally looking at a chart and And by the way, I always tell my clients to track deviations so that the other side can't come and say, oh, they're not exercising their Monday nights, they have class, or whatever it is. And I have very specific provisions for pickup and drop off. I have very specific provisions for what happens if, my tie's not on. What happens if school is closed? So if school is closed, when are the pickup and drop off times? Who's watching the kid on the snow day? Who's watching the kid on the teacher holiday? Who's watching the kid if it's a federal holiday and one of the parties has to work? And I spell that out. I tell people who tell me we're not going to have any conflicts, or it was an easy case to settle, at least on the custody side. I literally tell them, fine, we're still going to have this written agreement. Your children are only 12, 10, and 6. You might not always get along with your ex-spouse, okay? They might want to move. They might move further than 50 miles away. And so you can take this and go stick it in a drawer and never look at it, and you and your ex-spouse will just always work things out, but you must have it in writing. If you put in there, especially if you're representing a person getting less custody, reasonable rights of visitation is the same thing as no visitation, because reasonable is in the eyes of the person who has primary custody, period. So that language should never show up in any agreement that you do under any circumstances. It always leads to mischief, always. The boilerplate in here provides stability. That's not really enforceable language, although I've had some judges reference it, when you have a contempt or a modification and say, when you did that, ma'am, were you exercising good faith to try and fix it? But in terms of enforceability, it really doesn't have much meaning. But it's very important to the clients. It's very important to have in there. And even if the parties hate each other and they're reaching this agreement, it's important for them to know what they're committing to in reaching the agreement. Even if it's hard for them because they think the other side is the most horrible, inflexible, terrible parent in the world, if they're agreeing to some kind of custody schedule, this is a reminder that they're required to cooperate. So very, very important. Let's keep going here. And then again, I don't like this paragraph, fairly and equitably to divide. Every once in a while, you have a client that just says, no, I really don't want to spell it out. I don't know if I can share it with you because I have to look and see if there's metadata in it, but I actually have a whole template for all the federal holidays and school holidays. For children who are not yet in school, who are in daycare, I still alternate Thanksgiving, Christmas, or winter break and spring break based on the school schedule, either the daycare schedule or the preschool schedule. If the kid is not in preschool or daycare, I have a default provision that says that the parties will follow the public school schedule of the county where they live. Because I think having, even for a 2-year-old, I think having that vacation time, that extra time during the holiday periods and alternating it is important. For families that are Christian, Easter often is not, or Orthodox or regular Christian is not on the same day, usually as the spring break for a lot of schools anymore. Sometimes it is. So I often have the Easter weekend, including Good Friday, alternate because that's very important to some people. And then I have also a whole template for all of the Jewish holidays, the way it's written, as if they're Orthodox Jews, because we get spillover cases here. We have a number of Orthodox partners. But even for Jews who don't celebrate all of the, quote, non-work holidays, you can scale it down. Interestingly enough, for non-Jews, Hanukkah is not an important holiday on the holiday schedule. It's fun for the kids, but it's not really all that important in terms of religious observance. And again, you want to spell it out. And, you know, for people of the Jewish faith, custody exchange times are also equally important, particularly in the winter time, because you really want to do the exchange 2 hours before sundown. And there's actually a website that defines when sundown is for observant Jews. So that's also very important. The other thing you can run into with Jewish people is that for boys, they are supposed to accompany their father for Yom Kippur, and also on Friday nights, they go to shul. Usually women don't go to shul on Friday nights, they go on Saturday. Men go on Friday and Saturday. So those are weeds you may not get into. But regardless of the faith, you know, for example, there's a huge community of Orthodox Russians, Orthodox Ukrainians, Orthodox Greeks. You know, they're all the same church internationally, but they consider themselves separate, and they have a completely different calendar than Catholics and other Christian faiths. So another thing to keep in mind with these custody schedules. So you, unfortunately, I don't really care what people's religion are, but you have to ask sometimes to make sure you cover your bases. And then there's the part of the population that is not religious, don't care. All right, let's go down to 6. So again, this is boilerplate in every agreement I've ever done. And whether it's shared or sole legal custody, this is a critically important provision, because if you have sole legal custody, you absolutely have an obligation to consult with the other time. There are rare cases where a court might say you don't have to, either involving child abuse, domestic violence, or just the mother or the father may just plain be sort of whacked and you just can't have a conversation with them. And unfortunately, those cases come along, and because of the nature of some MVLS clients, you may see that more often than other types of cases. So this is a pretty important provision. In addition to this, I always have notice provisions about emergencies. You know, if the kid goes to urgent care or an emergency room or the hospital, 1 hour notice to the other side, period, no matter what, right? If there are doctor's appointments, they have to be notified. Even if it's sole legal custody, they may not have the right to make medical decisions, but I think they have the right to attend those appointments. On that point, some lawyers disagree with me. They think if you have sole legal custody, the other person does not have that right. Really want to spell it out in the agreement, okay? And this also has a mediation provision. Curiously, I have never thought that a failure to abide by this mediation provision could have an impact on a court ruling on child support modification, custody modification, or contempt on a failure to pay. But for the first time 3 weeks ago, Shannon and I, on a very complicated case, had the judge rule that way, and we were pretty shocked. And we're actually still debating whether to appeal. So that'll, because there's no case law on it. I mean, I think it's preferred, but people forget, or they just can't see their way to doing it. So that's a different question. You come down to child support. Why do I have different provisions in here? I don't even remember now. Oh, yeah. So the second one deals with college education, and it's got a name in there. I'll have to fix that and take the name out. Well, it's just a first name. So I never have clients, unless they insist on it, agree to pay for college. The reason I never have them agree to pay for college is A, there's no legal obligation in Maryland. There are a few states that it's discretionary on the part of the court. Massachusetts comes to mind. But the reason I never have it in there is because it can affect the ability to get financial aid when you fill out a FAFSA. So when I do write these in there, if you go down, it should specify that this obligation only applies after receipt of all benefits for which the child is eligible under FAFSA. And if you don't have any experience with FAFSA, that is the form that you fill out for financial aid from any college, university, or community college in the country. It's a federal online form. It's rather tedious. And one of the really unfortunate parts of the federal law on financial aid is that the entire household income counts for where the child spends more than 50% of the time. That means if there's a mother who doesn't work and has no income, but there's a stepfather who earns, say, $150,000 or more, child probably won't get much financial aid, which I think is totally inappropriate. 50-50, you can probably choose which household you use. That's important to remember when you're doing these. And I always use College Park, Maryland as my standard for paying it, not Harvard. Wow, our power just went out here. Or our server did, but fortunately I'm offline. All right, can everyone hear me still?
I can still hear you, Jack. I think we're still on.
All right, all our computers just went off. I'm on a remote, fortunately. Waiver of alimony. And I don't have an alimony provision in here. Typically, negotiated alimony is non-modifiable for a period of years, depending on how long the marriage is. We'll talk more about that in 3 weeks. This is, in my opinion, completely unnecessary language, the waiver of rights under the Service Members Relief Act, but a lot of attorneys insist on it, so I usually put it in. The fact of the matter is, the rights under the Service Members Civil Relief Act really have to do with whether or not the case has to begin or not, and whether or not the person is entitled to the appointment of attorney after they're served, and extra time they're entitled to. The other provisions of that law really deal with contract debt issues for people who go overseas. Doesn't have anything to do with divorce. But, you know, as we all know, you can't get a default order without the military affidavit. Medical insurance, let's go down to 11. So I've got to take these names out. I always agree to, and I always tell my clients to agree to, providing health insurance for the children until they reach age 25. Because the law allows it, and it costs almost nothing, right? Even if the person's paying their health insurance out of pocket, maybe it costs $200 a month. You can agree to split it, but it is so cheap to have a child up through age 25 on a parent's insurance still. It's crazy not to. And, you know, even with the most difficult recalcitrant clients, you can usually talk them into this. So anyway, so you can keep going from that. Marital property settlement. So there are a number of provisions in here. This is just a provision for a lump sum. Just so you know, if for any of you who may be interested, the provision of the tax code that says that's not taxable are quoted in here. Some clients actually are concerned about that. Then personal property. There are a few things judges hate more than a dispute in court over personal property. Who's going to get the silverware or the knives and forks? So, you know, in rare.
And I will add, few disputes attorneys hate more.
Yeah. So what I do, if there are people who really, really can't agree on how to divide up the household furniture, I pick a senior judge I like with the other lawyer. We mandate that they can have a email to that judge for binding arbitration. We agree to no more than 1 hour. They split the cost of the arbitrator, and the arbitrator is just going to go through a list and write HW, HW, and be done with it. If I really have to do that. Anyway, this is the boilerplate language for cars. The gift certification is fairly important. That's a form unique to Maryland. Legally, I don't think MVA has any business demanding that in the situation of a husband and wife transferring title, but they do. They've been doing it since I was born, so it's just not worth arguing about. And then the bottom is whatever's not specified in this agreement. This is really the same thing as the waiver of claims, so it's sort of added language. Anything in the name of each party that isn't dealt with in this agreement belongs to that party. That's a very critical provision, has to go into every agreement. Let's keep going here. Personal property, something. Anyway, so more personal property, alternate language. This is where they actually list things which you want to do if one party has not taken what they want out of the marital home. Make a list, make it an exhibit to the agreement. And this applies in divorce cases involving rich people, poor people. You know, who's going to get the TV set in the basement? Who's going to get the TV set in the bedroom? You know, who's getting the bed that the, you know, in-laws bought when you got married as a wedding gift? All that stuff has to be dealt with, okay? Keep going. Same thing about payment out of a savings account. Shorter language. Oh, just a waiver when a car is already in one person's name. All right, you can keep going here. Life insurance. So if you have a marital property award paid over time or alimony over time, this usually won't apply to MVLS cases. Usually you provide for life insurance to cover what's still owed for the person who's owed the money. Most good lawyers will demand a provision like that because term life insurance is really cheap unless you have a very, very sick client you're representing. It doesn't happen too often. And sometimes the other side knows that there's life insurance and demands that there be a life insurance policy just covering the children in case someone dies. Keep in mind, however, that if one of the parents does die, and over the years I've had that happen quite a few times, you know, the surviving parent is going to get anywhere between $1,200 to $1,800 of payments a month from Social Security, at least until the child's 18th birthday. When I started practicing law until Ronald Reagan, so I guess that was before I was practicing law, it used to go to age 21 if they were in college, but he got rid of that. So, and then this is provisions then about the verification of the life insurance, which is not always simple because life insurance companies have no obligation and you cannot make them mandatorily make someone a beneficiary except for insurance policies that come with health insurance that are governed by ERISA. If you have a policy governed by ERISA, you can force them to mandate a beneficiary, okay? All right, let's keep going here. So, and I see a question, so let me just look at that. Okay, the question is, what do I do about children who are in college at the time of divorce? You know, it's the same thing. I usually won't put something in writing, but if I do, it has that provision that anything they agree to is only after application of all financial aid funds and loans. The other thing also that I just remembered is it should also include after application of any 529 accounts titled in the name of either party. If there are 529 accounts, I still don't require that they be applied until after there's financial aid. Although I think that can reduce your financial aid if there are 529 accounts. I can't remember that right now. They keep changing the law on that. Obama changed the financial aid laws quite a bit when he was president with the help of Congress. So, all right, marital home. So, this is a provision for the sale of the marital home. There are provisions for what happens if the real estate agent thinks that something needs to be paid to improve it. If the offer is within a certain amount of the original listing amount that they both agreed to, like it's 95 or 90% of that listing amount, either party can sign for both parties. Other than that, they have to both agree. Upon sale, how the proceeds are divided, usually 50-50, not always. Sometimes this is adjusted for marital property. Sometimes it's adjusted if there's really a valid Crawford claim. We're not going to get into Crawford credits in this seminar. It's just too many moving parts with that, and almost never applicable. If you keep going down here, this is more of a use and possession provision. The courts can only give 3 years use and possession, but you can agree to almost anything. I have had clients agree to use and possession until a kid moved out for college. They don't have to, but they wanted to. In those situations, I just think you're better off settling on the house. The problem you have sometimes is that the economically dependent spouse can't get a mortgage. And that can be a problem. On the other hand, even the economically superior spouse, if the wife or husband is living in the marital home, isn't going to want to do use and possession for very long because it can make it very difficult for them to buy a house. A lot of mortgage companies will frown on you having 2 mortgages at once unless you're quite high income or you're willing to pay a very high interest rate. All right, so we can keep going down here. All right. So that's a provision here. Then about selling the house after that's all done. I don't keep going. I want to see if I have a provision in here about arbitration in disputes. So you can go a little faster. So you can see I have a bunch of marital home provisions here. Keep going. 4 of them. Yeah. A lot of different options that I've used over the years. And all right. So let's just talk about this for a second. When you have parties that really don't get along and they're selling a marital home, the problem with any of those provisions on the marital home is in the event of a dispute, if you can't agree, your only solution might be to file a complaint for sale in lieu or for the appointment of a trustee, which is very expensive for both parties. So what I do is I will again pick an arbitrator, one of the senior judges, and then same thing, both parties can submit their position. The arbitrator will make a decision with or without sort of meeting with the parties on anything from lowering the list price to accepting an offer to making improvements that the real estate agent wants, the whole gamut of things that may be involved in settling on a house, down to appointing a trustee to sign one spouse's signature if the other spouse just is being recalcitrant and won't do it. Because otherwise, a sale in lieu of petition can be a very expensive post-divorce expense. All right, let's keep going down here. Apartment lease, I don't think I've ever used this provision. Debts, I've got a bunch of provisions. One is that both parties walk away, pay their own debts. Usually by the time you get a settlement in divorce cases, people have gotten rid of all the joint credit cards or all the authorized signers on credit cards. Usually they do that when one party uses the other party's credit card to pay a fee to an attorney. That's always the point at which credit cards seem to get canceled. In Maryland, courts do not have the ability to allocate debts. In extreme cases and unusual situations when one party has like a huge amount of debt and it was clearly both parties using it, the parties just went into debt, you might have a judge alter a marital property award, but if there's no marital property, the judge can't do anything. It's just the way it is. So, so you can see again, I have a bunch of debt provisions, one where the husband assumes responsibility. That could equally be a wife. Just in the old days, I think this agreement started out when things were a little uneven between husbands and wives, still are some. So it's always the husband taking on responsibility, but I've had more than a few cases where it's the wife these days. I haven't updated the form. Anyway, so, you definitely want to cover the issue of debts between the parties, even if it's a walkaway. All right, let's see what's next here. Pension waiver and quadros. So I'm actually going to have a discussion when we do marital property about pensions, because you will occasionally see pensions in your cases. Usually if you're representing the economically dependent spouse, then the other side may have pensions, and there's some critical work you have to do that many experienced attorneys don't do properly. I actually have an appeal right now where a very, very experienced attorney assumed that a pension was one thing. It turned out to be another. He lost in front of a judge to reform the contractor, and now it's on appeal. So you have to be very careful with these and make sure you have the right information. This is a waiver. No one in this firm does quadros except the simplest ones because there's too much malpractice liability. So unless it's really simple, like a federal pension, a thrift savings plan, or a 401k, we don't do them. State pensions, we don't always do because that actually has a lot of moving parts in the last 10 years. We don't do any ERISA regulated pensions with private companies anymore. Sometimes we don't do 403Bs for nonprofits because those are more complicated. So there are lots of good, not a lot actually, there's a few good attorneys around. They charge about $800 to $1,000 for doing a quadro, and you almost have to do that to have it done right. So, and even they make mistakes, because one of the cases where I testified as an expert in this was a case where the drafting quadro attorney did it wrong. The person who was liable for that mistake was the attorney who represented the other spouse who'd never reviewed it, who just signed off on it without really reading it, and it was very wrong. And the husband lost a lot of money as a result. The court restored it, so fortunately that lawyer was off the hook for the malpractice case. The judge decided it was a mutual mistake. That's on appeal now, so we'll see. Income tax returns. So again, all kinds of formulas in here about how you divide up liability for the final tax return of the year. I don't have language in here about allocating child tax deductions and child care credits. So the law used to be in a case called Wasif versus Wasif, that the court had broad discretion to allocate those deductions and credits, and parties often reached all kinds of agreements. The law in Maryland has changed. There was a case about 12, 13 years ago that basically says that the party, that basically it's going to follow the IRS regulations. The IRS regulations give the credit to whichever party has the children more. And if it's 50-50 custody, the IRS regulations give the credits to the parent who pays more expenses, which is usually the parent who has the higher income. So if you can't reach an agreement, that is now the default. And you will run into that. And why that's important is because if you have a low income client who is getting the low income, I forget what they call it, the low income tax credit, having a child is mandatory to get that credit. So it's critically important. So if there's only one child, the economically superior party won't be able to claim head of household during the years he can't take it. And that will cost them quite a bunch in taxes. And the years that the economically inferior party can't get it, they will lose a substantial tax benefit. So it's pretty important when there's only one child. When there are two children, you split it. 3 or more, you alternate like 2, 1, 1, 2. I don't have that language in here, but it's very easy to write. But it's an important thing to remember, even in MVLS cases. So, especially because your client might just be temporarily economically inferior and qualifying for MVLS's services. You know, they may have some illness that they'll recover from. You don't know. All right. So I'm not going to go through each of these income tax provisions. You can look at it at your leisure. There's like 4 of them. Jewish divorce or get. This is totally unenforceable. Civil courts cannot constitutionally enforce this provision. However, if you have Jewish clients, even Jews who are not very observant, okay, but they're married, they're still probably going to want a get or a Jewish divorce. I can tell you that if this provision is in the agreement, the Jewish rabbinical court will ostracize the husband for refusing to give a get fairly severely if they refuse, if there's an agreement like this. That is not across the board. I'm not going to get into that. But so if I have Jewish clients, I'll usually keep this in. Counsel fees, obviously pretty important. And then you can just sort of keep scrolling through. I think everything after that, right? So everything after counsel fees is boilerplate that I put into every agreement, who negotiated it, who's representing it, independent counsel, parties fully informed. Let me stop there on parties fully informed. Go back up for a second. Sometimes both parties want to settle a case before you've done discovery. So instead of this provision, I write a provision that says both parties have had the opportunity to do discovery and litigation on the other party's assets. They have chosen not to do so. Accordingly, counsel can make no representation about whether all assets have been properly considered. The client agrees that they want to proceed in this fashion, and they recognize that, they can't come back later and bring any action against the attorney for failure to, pursue those investigations because they've chosen not to do so. I write pretty strong language about that because I don't want the client coming back 3 years later and saying, you should have told me that, he won $250,000 in the lottery. Well, that's the danger of entering into that kind of agreement. I also have a provision, which is not in here, on after discovered assets, that if I can prove later on that someone lied about their assets, I can come back and go after it, and there's a penalty provision. Some clients insist on that, but quite frankly, I've never had a case where that happened. So, it's pretty hard to hide assets in this day and age. Here's more pension language. I'm not sure why that's here instead of earlier. It's just out of order. Mutual release, hold harmless. Reservation of grounds for divorce, probably totally unnecessary these days now that there's no fault grounds. And that's just a statement of what the law used to be, is you could not compel the other party not to sue you for adultery if they committed adultery, even if you wrote it. The law said that that was against public policy. Further insurances, this is pretty critical. So, that basically means that both parties have to sign any forms required of the other party. So that doesn't apply to like a joint custody decision, like getting a passport, but it does apply to signing the papers necessary to transfer a car, sell a house, and so on. Incorporation is critical in Maryland because of very obscure common law language. I can just tell you that the reason in Maryland, and I don't know if any other state still does it, that it has to be incorporated but not merged in the judgment of absolute divorce, literally traces back to the existence of ecclesiastical and the king's courts in England 500 years ago. And why we've never changed the law on this is a mystery to me, but it is the law. And by the way, because of this, to file contempt proceedings for anything other than alimony, custody, and child support is an absolute waste of time on marital property because the law is so arcane. If you have a breach of marital property, don't file a contempt, file a breach of court order action. Modification and waiver, again, critically important. I have had people back and say, well, we agreed to something else. If it's not in writing, too bad. Severability, same thing. You've got to have that in there. Really, that's got to be in almost any written contract. Controlling law, very important. choice of law was a subject I hated in law school, but basically this controls choice of law over the common law or statutory law of any state where this might get enforced. And I have had cases where an agreement got forced in a state other than the one it was entered into. Okay, so I've been talking a blue streak. I've got some more questions here. So let's see what they are. Can child support be waived? No. Can a marital home be given in consideration in lieu of child support? So the answer to that question is probably not, but under the law, payment of expenses for use and possession is a factor in child support. And on the child support guidelines calculation, can either be grounds for an adjustment of child support under the statute that says that a court can do so if it's in the best interest of the child, or you can put it in as an other expense category. You know, some judges are puritanical when it comes to following the guidelines and will only do a deviation from the guidelines under extraordinary circumstances. That's if it's an under guidelines cases, which is most of the MVLS cases will be. And some judges will do it at the drop of a hat. You know, if you come in and say, Judge, the only way we settled the custody part of this case and these clients hated each other, and, you know, you say all this out of the presence of the clients, is to do this, you know, generally charged with child support. So please, 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 please make a finding that this deviation is in the child's best interests. Most judges will generally do that. But I'm also kind of a Puritan, so I really reserve that for the most unusual cases. I tell my economically superior cases, pay the damn child support, right? My economically dependent usually want the child support, although for some reason, women, this is just my experience, women always want the child support. Men half the time come in and say, oh, I don't care whether she gives me child support. I've never understood that, but I've never seen a woman come in and say, I don't want the child support, only men. I don't know if that's changing, but I have had that happen twice in the last year, and I'm like, okay. But judges are not supposed to allow you to do that. I mean, the cases are clear. It's a matter of public policy. It's the right of the child. It was the first case by the Supreme Court after the child support guidelines were changed from being discretionary to mandatory. And basically, there was a judge who deviated from it, and the Maryland Supreme Court slapped his wrist pretty hard and said, the legislature said mandatory, it's mandatory. So, oh, all right. So that is separation agreements. How are we doing on time? So I still don't have a computer. Let me reboot.
Jack, there is one other question.
All right. Oh yeah, I see. Let me look. Did I hear correctly? I can put, no, that's in the chat. All right, here we go.
For arbitration, how does one hire a judge? How does one find and reach out to one?
Oh, I got it. Well, you can ask around. I mean, the 4 go-to judges in Baltimore County and Baltimore City, everyone knows, so I'll just say their names. It's Judge Kathleen Cox, Judge Ruth Jacobowski, Judge Diane Leisure, and just now, because he just retired, Christopher Panos. Those are the 4 judges that are considered just really excellent mediators, compassionate when they listen to people, phenomenal mediation and listening skills. But at the end of the day, they were judges, and if they have to pull the trigger on something, they'll pull the trigger while they're being gracious and thoughtful with you. And as arbitrators, you know, they'll just listen to the evidence and reach an agreement. To be clear, how if you use one of those senior judges as an arbitrator, the judicial policy under the canons of judicial ethics is they cannot then act as a mediator. It's a conflict of interest. You can, however, waive that conflict. So you need to be aware of that. Some judges, however, won't do it. So judges who, by the way, are settlement judges in court also cannot be arbitrators for you later on privately. Okay. Again, it's just considered unethical on the part of the judge. You know, they can't earn money because they were the settlement judge is sort of the idea. So those are the four around here. Tim Martin used to be one, but he stopped doing it after he became ill, from which he is mostly fully recovered, thank goodness, but he was sick for quite a while. So those are the four. And they have enormous family law experience, a minimum of 40 years each. So, yeah, great question. There's another question now, so let me take a look at that one. The answer is, can you cover children over 18? Absolutely. I mean, you know, it's like any contract. You can agree to anything you want. And with alimony and any kind of payment for anything, you can pay for anything you want as well. Keep in mind that if you do enter into an agreement to pay for college or anything after the age of 18, if both parents agree they want to change it, believe it or not, it is enforceable by the child. So you might not be able to change it. So in other words, you've agreed to pay for all expenses of college after application of anything or no application of anything from financial aid. The child can sue you for the money. So it's considered enforceable by a third party in Maryland. I don't know if that's true in every state, but there's clear case law on that here. So, and I don't think you can agree to not have it be enforceable by the child, or at least I wouldn't want to take that risk because there's no law on that. So that's a great question. So, all right. I don't have my outline in front of me, so give me 1 second. What was the ending time on this supposed to be? Nancy, you're on mute.
I think Shannon is going to begin her talk on custody at this point.
Okay, great.
Oh, no.
Well, I think
no,
first,
No.
Jack, we were going to touch on
Yeah,
new divorce laws and subpoenas.
that's correct. And subpoenas, that's correct.
All right.
Laws and subpoenas.
All right. I mean, we don't need to spend a lot of time on this. The fact of the matter is that the new divorce laws are so simple. It's kind of ridiculous. The MSBA for our book asked me to sort of ask Deborah and I to write an update on the new divorce laws. It took us both about a half hour each. We split it up. I mean, there's really nothing to it. The biggest thing you have to remember about the new divorce laws is that it's even more clear that there's really no residency requirement to file divorce in Maryland. The residency requirement only applies if the grounds for divorce occurred outside the state of Maryland. And I actually can't think of any factual scenario where that would be the case. So I just don't think that applies anymore. But judges are so used to seeing it and asking it when they grant a divorce, you kind of want to put it in there because they just automatically do it anyway. You know, it takes the judges about 2 to 3 years before they stop asking questions they don't need to ask anymore when there's a change in the law. The most important aspect of the change in the law is the change in the law does not eliminate fault as a factor in the division of marital property or in the granting of an alimony award. In my experience, it's very rare for there to be a deviation in a marital property award because of fault. The only case I can think of in 30 years where it happened was when there had been really serious child abuse by the husband. And in that case, the wife got virtually all the marital property, which was the marital home, because otherwise she couldn't afford to keep the marital home. That was a very unusual case. I've never seen judges do much. I've never seen anything that other than a 50-50 split, unless it was financial misconduct. So that's different. For alimony, judges do consider fault still in granting alimony. You know, if there's more than routine adultery, like multiple adultery partners or a long-term adulterous relationship that got hidden from the spouse, or, you know, seeing a prostitute and putting the person at risk of STTs, judges might factor that into an alimony award, but only if alimony is justified to begin with. So that's really about it on the new law. I really have little more to say about it. Be happy they've simplified it so much. So, you know, and especially for your clients, and especially, by the way, the most important thing is, you know, if you've got a victim of domestic violence with no money and nowhere to go, You know, if they think they can live in the marital home without risking themselves, they can stay in the marital home and file for divorce. And that's really, really important, because I can't tell you the number of times a woman came in, was a victim of marital violence, and couldn't move out. She had nowhere to go and wasn't willing to move into a shelter with their 3 kids, and couldn't figure out how to file a divorce, because when I started practicing, it wasn't clear that all marital violence constituted cruelty of treatment. You know, that came later. So, you know, the old common law, you know, slapping your spouse around was not cruelty of treatment. It was just acceptable. So that's 30 years ago. It's hard to remember that that used to be the case, but it did, and it's not that long ago, you know, in my lifetime. So, anything else? I think I covered everything that's important, Shannon.
I would just add, as far as irreconcilable differences, those usually involve some issue or set of issues in the marriage that the parties can't work out. Could be anything from finances, parenting decisions, values, fundamental disagreements that they have with their spouse. And that is important to kind of set those grounds in your complaint when you are pleading irreconcilable differences. So just to have some sort of support for more than, you know, I think the courts are generally accepting the language that parties have reached a point in their marriage where they no longer can reach an agreement on issues arising out of their marriage and wish to pursue lives separate and apart from one another. It's important to kind of give some sort of support for what those irreconcilable differences are.
Right.
There may still be some, oh, go ahead, Jack.
Go ahead. That's fine. You finish up. I thought you were done.
There may still be some question as to whether or not the parties have to agree on whether there are irreconcilable differences. But I think I definitely have, and I think Jack would agree with me, that most jurisdictions have taken, and we will continue to see that they take the approach that just claiming irreconcilable differences is irreconcilable in and of itself.
Right. And when Deborah and I did our little treatise on the new statute, we actually did take the time to look at the 2 states that had irreconcilable differences in a big way, which is California and Florida. And they accepted almost anything for irreconcilable differences. Florida had a little twist on the law that said if one party said there weren't irreconcilable differences, the court could order them into counseling for a period of time before the divorce could go forward, but that was unique to Florida. So bottom line is pleading almost anything suffices under the statute. All right. All right. Your turn, Shannon, custody.
All right. So as most of us know, custody really is comprised of 2 main components. That is decision-making authority or legal custody, and access and visitation or physical custody. I would say, to the extent that you can, try to steer away from using terms custody and visitation, as it can have more of a negative connotation. Courts are really trying to move towards a more collaborative approach when it comes to this area. So we tend to use the terms, or like to use the terms of access or decision-making power or authority. We're seeing that those terms are becoming more widely used in trending away from sole custody, or, you know, terms that are more alienating to one parent. And that is also to say that the current trend now, which has been the trend for a while, is really to give both parents equal access. Courts generally, we have been seeing, are of the belief that 2 parents are almost always better than one, even if one of those parents really does fall short of their title as either mom or dad. I would say the best advice for talking with clients to communicate that trend is to speak with them clearly and effectively. You may need to politely disabuse your client of the idea that they may win to get primary custody or sole legal custody. We really are seeing courts word that less and less these days. And that really is true, even if they tell you all of the reasons why it would be unfair or why the other party doesn't deserve to have as much or any access. We really do see cases very, very, very rarely where a party has no access. Typically, the least amount of access we would see would be maybe an every other weekend with a dinner visit every week. Courts really do like to have both parents involved, or at least have the opportunity for both parents to be involved, because again, the standard for custody is really the best interest of the child. And because the parties believe that a child's best interests really are served with having both mom and dad present in their lives, courts we have seen will bend over backwards to make that the case. Now, it's not always the case that parties will have shared either physical or joint decision-making power. Some reasons that the court may or could lean towards granting one party more access or decision-making authority over the other may be a history of child abuse or neglect. Certainly, if one parent is demonstrably abusing the child, that would be grounds, among other things, to limit access with that parent.
And let me have you pause there, because we forgot to make a note of this in our outline. There is a specific statute on point, and it's Family Law 9-101. And what that statute says is if a court finds that a parent has abused any child, the court cannot grant any access to a child in a custody or divorce case except under circumstances that protect the emotional, psychological, and physical well-being of the child. It's a very, very, very high burden. And I've only had one case where a court, and that's true, unless the court makes a finding that there is no likelihood of future abuse. That's the burden that's so high. I've only ever had one court make that finding where there was a prior finding of child neglect. So, you know, you just keep that in mind. If there's actual child neglect that you can prove, the judge has no flexibility. A lot of judges don't know that, by the way. So, yeah.
There's a case directly on point. I don't have it in front of me, but we can circulate that after the fact that speaks to that point directly. But just to follow,
it's Wolodarski.
There's I think a new one.
Oh, a new one. Okay, fine.
Yeah, past couple of years. But to Jack's point, just to follow up on that, it does have to be that the court has made a finding that there has been some abuse. It's not just that the mom or the dad says that the other party is abusing the child. I had that instance recently in a case that I had. It was a very volatile relationship between mom and dad, and she suspected that maybe dad was mistreating the child, but never filed a protective order, never called the police or CPS, never took the child to the pediatrician. So all of it kind of goes back to the veracity of, you know, what your client's telling you. You really do have to investigate before you file your initial pleading, but also just to make sure, you know, that you are, when you're claiming that one party has abused the other child, just to make sure that you are taking into account you do have some sort of evidence to make those claims and back up what your client is saying.
Right. And one of the two pleadings we shared with you, by the way, you will see the allegation that mom took the child shoplifting. Now, we say it in very polite language, but when you read the language, you can figure it out. That is absolutely neglect.
Another reason may be spousal abuse. Similarly, the court may limit access to the child if one party has been engaging in spousal violence or abuse to the other. And in fact, spousal abuse in front of the child is grounds for mental abuse of the child. So just keep that in mind. Let's see what else. If there is a history of unequal access, the court may continue that arrangement, but not always. You do need to be very careful about this one because whether genuine or not, if one party does assert a desire to be more involved, courts are more inclined to give a parent the opportunity to be more and even equally involved. Frankly, I have seen this instance all too many times, and it is infuriating for clients because, again, they don't feel that it's fair. In fact, just this past winter, I did have a case where mom was the primary caretaker for the child for at least the first 18 months. And suddenly dad is filing for custody. He wants to be involved. And guess what? The court did not hold the lack of his involvement for the first 18 months against him at all. And he actually walked away with shared physical custody, much to mother's chagrin. So even though it has been a trend, perhaps in one of your cases, it's not always going to be the case that the court will continue that arrangement. Certainly, if there are instances where mom has been the primary caretaker for the past 10 years and dad has been MIA or not wholly involved, the court could say, all right, well, in the best interest of the child, they really have adopted a schedule where they are in their routine, they're attending their school, and we're just going to keep that the way that it is, perhaps give more access to dad, but may not shift from a sole physical to a shared physical custody schedule. It just depends. It's highly, highly, highly fact specific. Distance in that same vein is another reason why a court could defer from a shared custody schedule or 50-50 custody. Courts tend not to adopt a 50-50 schedule if there is a substantial distance between the parties, just because it makes it so inconvenient for the kid. You really don't want a 4, 5, 6, 10-year-old spending an hour and a half in the car one way, to mom and dad, or a couple of times a week. So again, what they may trend to do is perhaps extend the weekend visitation, perhaps a Friday after school to a Monday morning, or maybe even an extra overnight on that end. Give mom or dad the ability to see the child every week for a dinner visit, perhaps 2. That is, again, not to say that just because the parties live far distance from one another that they won't have meaningful access, but it's unlikely that you're going to be seeing the kid shuttled back and forth every couple of days. And by that, I mean like a 2-2-3 schedule, maybe even a 5-2-2-5. Sometimes work can also be a factor, but not always. Really just depends, but typically you would see this in shift work, nurses, medical staff, road workers, perhaps, people that may work nights or weekends. And you may even see sometimes the court shift from a shared custody to a sole custody if there is a potential threat of alienation of the child. If there is evidence that a child's tie to either mom and dad is, or excuse me, mom or dad is threatened, or custody given to that particular parent, you may see that there will be a complete shift. I know one of our colleagues recently had a case where that was in fact what the court ordered. The children were fiercely bonded with mom. There were adulterous relations on the part of father, and as a result, mom didn't withhold access of the children from father, but I think that's where what the court was concerned about. It certainly there were threats that it could trend that way. So what the court did was they actually awarded sole custody to dad based on mom's behavior. So that's just something to keep in mind. If you do have a parent who is taking all of the custody and not allowing any custody to the other parent, you need to have a very serious discussion with your clients. And that is, courts really do frown upon that because, again, they really value the relationships between mom and dad with the child. So any parent that threatens the absence of that relationship, we have seen trends where that party is in and of itself kind of punished for their behavior. So
Right.
again, just advise your clients that you need to make sure that the lines of communication and opportunities for visitation are open.
Let me just add there, Shannon, that,
Yeah.
if you have a parent, and we've had this twice here recently, once where we represented the mom who lost custody, and one where one of my colleagues was the best interest attorney, where one of the parents was not objectively reasonable about the other parent. And they had their reasons, like the other parent was never involved before the separation. No matter what you said, the other parent just absolutely firmly believed that the other parent was unfit, but they just weren't unfit. They were just fine. That is not going to go well for your client, because if I've learned anything, what a client is telling you in your office, they probably can't help themselves when they get on the stand, and they'll say the same thing, and it will not go well for them. And, we do everything in our power to educate the client about what's going to happen. And sometimes for doing that, you get fired, by the way. But, it's your obligation to warn the client when they're being that way. And you do, at least once a year, we run into someone like this. And, those are the kinds of people that you see burn through 1, 2, 3, 4 lawyers, because they never hear what they want from the lawyer. And by the way, when we have a paying client we're going to be their third lawyer, we ask for a massive retainer up front, because we know it's going to be a problem when someone's had 2 lawyers before us. So that's what you see, is just people who cannot be objectively reasonable, and it doesn't go well, and it doesn't go well because the judge really worries how that's going to impact the other parent.
Yeah, and oftentimes like I started out this presentation, divorce in custody is very emotionally charged, and oftentimes you will see mom or dad kind of harbor that animosity towards the other parent through their desire to have access with their child. So in ways of punishing mom or dad for the things that they did to them personally. So something to keep in mind, when you are handling these types of cases, is you really need to make sure that your client is fully aware, cognizant of the standard that the court has, and that is what's in the best interest of the child. not what is best for mom, not what is best for dad, but what's best for the child. And oftentimes when you have these clients that are very emotionally charged in that way, it's difficult for them to see and make that connection to the best interests of the child when they're on the stand. So all of their testimony needs to be tailored to what's in the best interest of the child. And if the court starts hearing, well, dad did this, dad did that, and it's, harboring some animosity or ill will, that's when you really get into trouble. So something just to keep in mind. I see that there is a question in the chat here. What are your thoughts on modification of child custody? When child's mother died a week after birth, dad was present but agreed to custody to maternal grandmother, but 5 years later now wants custody in another country. So I will say that we will be talking about third-party visitation and de facto parent next time. As far as custody in another country, I know Jack is the Hague expert on that. Do you want to say any
Sure.
quick?
Yeah, I mean, when we
thing
talk
on that?
about third-party custody and de facto parent in 3 weeks, this is a classic MVLS fact pattern. I don't know about the other country, but the 5 years of custody with a grandparent and then the other parent wants it back. I mean, I can't tell you the number of MVLS cases I've done with practically literally that fact pattern. The fact of the matter is after 5 years, under the standards of McDermott versus Doherty, and then, oh God, it was my own case and I'm blanking on the name. Allmiller versus Allmiller, which are 2 of the published opinions on the topic, and there are a couple more recent ones. The court would not change custody. That would be considered extraordinary circumstances. And we'll talk about it more, but the definition is an extraordinary circumstance is any issue that if the court acted upon it would be detrimental to the best interests of the child. And I think you can make a pretty strong argument that changing custody of a 5-year-old at that point would probably be detrimental to the child. Just because we have a little extra time, I'll digress for a second and talk about sort of the international issues. I'm not going to spend a lot of time on this. The United States and almost every country in the world except China, most of the Islamic nations, a few of the African continent nations have not signed the treaty, but most countries have signed a treaty called the Hague Convention on the international aspects of the kidnapping of children. That is a jurisdictional statute. So the statute has a number of provisions that determine what country is determining custody of the child. Courts in the United States are going to be very reluctant to allow travel under those facts to a country that is not a signatory to the Hague Convention. So if you have someone, for example, where the parent is from Syria and wants to take the country to Syria, I'm not sure a court will allow it. The most famous case on parental kidnapping in Maryland is the Condliffe case, my colleague Stephen Cullen. And in that case, the Egyptian family was very, very wealthy. Mom had visitation of one child. The children were split between the parents, had both children, went up to New York for a weekend, boarded their private jet, flew off to Egypt, and dad has not seen the children since. And I think the children must be 18 by now. Grandma, who participated in that, got arrested in Europe on a Interpol warrant and was extradited to the US, spent 3 years in jail for kidnapping those kids, but mom's never left Egypt, and terrible case. So anyway, so you get the picture. So if you have these international issues come up, you can Google search and figure out what attorneys to talk to. It's me, Steve Cullen. There's a few others. Another guy in Montgomery County I've worked with, who's a great lawyer, but I just can't think of his name. But there's a few of us around. Doesn't come up too often. But if you have visitation in a foreign country, you definitely need to check with someone.
Definitely. So as far as shared legal custody, I just want to touch on that briefly. Now, legal custody can either be sole or shared, obviously. But something to keep in mind is even if you have a joint decision making, you can have the ability or you do have the ability, excuse me, that one party may have either sole or tie-breaking authority on one particular area of legal custody. So if it's a matter of medical concern that is really important to one party, or school, we had that case very recently. The parties actually agreed that mom would have legal custody when it came to school decisions. You can also do that in terms of joint custody, where one party may have a tie-breaking authority on school decisions. So if you really get to a point where this would be for settlement purposes or mediation, you're really at an impasse because neither party wants to give up control over legal decision-making authority. But perhaps it's not effective for one reason or another. Something's really important to one party, another area is really important to another. You could kind of split the difference there and give one party the ability to make medical decisions, one party the ability to make schooling decisions, and call it there. So that's just something to keep in mind in terms of going forward. I think I haven't really seen the court do that specifically. They'll trend to either just giving one party either sole legal custody, which again is not the norm, or joint legal custody, and if it warrants a tiebreaker, perhaps giving one party general tie-breaking authority. But again, just something to keep in mind. We touched on the best interests of the child standard in terms of what is in the best interest of the child. The court does have to consider a number of factors. Of course, when the courts grant custody to one party or the other or both, they do have to base their rulings on something. So the Maryland Supreme Court and the Appellate Court of Maryland have delivered a list of factors to be considered. The first case was in Montgomery County v. Sanders. That was in 1977. So these cases have been around for a while. And those factors then were expanded in Taylor in 1986. Those factors are largely similar, but they are worth mentioning, so I'll just go through them. Sanders, the Taylors that the court set forth is the fitness of the parents, the character and reputation of the parties, the desire of the natural parents, and the content of any agreements between them. That could be something like a written agreement, or how they have been handling things in the past. So history, the potentiality of maintaining natural family relations. That really goes to, again, keeping both parties involved, but also are the parties going to keep grandma and grandpa and other family that may be close involved in the children's lives? That's something that the court likes to consider. The preference of the child, at least when the child is of sufficient age. And that really depends. I don't think that there is any hard and fast rule, but that could be anywhere from the age of 12. If it's a girl, and a little bit later, 13, 14, if it's a boy. Any material opportunities affecting the future life of the child. Perhaps one party is able to, get them into private school, something of those nature. That really could be anything, but just something, again, for the child, the court to consider. Age, health, sex of the child, the suitability of the residence of the parents, and whether the non-custodial parent has adequate opportunities for visitation. That's not to say that just because someone has a better living arrangement, they won't get custody. But certainly if, mom or dad is sharing a studio apartment with 3 children and the other party has a 4-bedroom home, you're probably going to see that the children are spending a little bit more time in the larger home just because they have better living arrangements. You really don't want 3 children and mom or dad sleeping, in the kitchen, on bunk beds. The court's not going to find that to be the best interest of the child. How long, oops, hold on one second. How long the child has been separated from the parent who is seeking custody. Again, this really, this goes to a number of factors, but particularly, it goes to what we had just been talking about is potential alienation of one parent from the child. So, if you have a party that is keeping the child from the other, you may have a situation in which the court wholly changes custody, or you may have a significant amount of custody being granted back to the party that was deprived of access for such a long, extensive period. The effect of any prior voluntary abandonment or surrender of the custody of the child, again, just kind of goes to the history. Most courts really don't hold the lack of involvement against one party unless it's particularly egregious, and even then, I think most courts are of the philosophy that notwithstanding, a parent can have a change of heart at any given time. They may not have necessarily wanted the child at birth. They may have been, struggling with certain hardships up until a point, and now they are ready to become, mother or father. So court really doesn't punish most parties for their lack of involvement of the child up until they are seeking custody.
Right. And let me just add there, historically, when I started practicing law, you really saw more of a dichotomy between men and women. Not always, but typically, men weren't very involved in their children's lives until they sort of hit 4 or 5 and became more and more involved as the children got older. And that's much less true today. You hardly ever see that anymore. You still see it sometimes. But and it's a big societal change in this country. But, then what you would have is you would have the father coming in, realizing that they're no longer going to sort of have that contact with the children through osmosis just because they're around in the marital home. And they come in demanding like major access with the child. And then you have the wife or the mother going, wait a second, they were never doing this when we were together. Why do they get to come in now and say, this should all change? Well, you still see that to a lesser extent, and whether it's just voluntary or whether there's actually some withholding of access, like Shannon said, courts are very much going to lean to increased access. You hardly ever see every other weekend visitation anymore, even when it's not 50-50. You see a longer weekend, maybe an overnight during the week. You just see more time granted, even now, to the non-custodial parent, even when there is a court decision.
So those were the Sanders factors, and the Taylor's factors, again, very similar. But this kind of goes more towards the ability of the parties to co-parent, and that is the willingness of each party to share custody. It's not a great idea to have your clients testify that they are not willing to co-parent with the other. I've had a few cases where that has been the case, and we have had to do some very significant coaching. But certainly, your clients are entitled to their opinions, and if they are valid, I do think that there is reason for each of those clients to share their concerns about co-parenting with the court. You know, that could be something like, I'm open to co-parenting. It's just been really difficult in the past. I have concerns about mom or dad's ability to communicate effectively, and then supported with their testimony and evidence on those points. The psychological and physical fitness of each parent. Usually there's not much evidence to these particular points, but, you know, certainly there may be, you know, if you have a disabled client or the other party is disabled and unable to get around effectively with a young child, that may be something that the court would consider. Certainly any psychological or mental abuse, again, like we talked about previously, would certainly be a factor.
Yeah, but let me add on that, especially for these MVLS cases. You know, just because a client doesn't have the financial resources of the other person, most courts aren't going to pay too much attention to that. They're not going to prefer one parent over the other based on poverty or levels of income, as long as they're both fit parents. That's the first thing. Second thing, I've seen some very disabled parents get custody in a wheelchair. I represented a blind woman many years ago, and you know, she had to stop working after she had a kid because she spent her day arranging rides everywhere in the world with this whole group of friends. But you know, there were like 20 people she relied on to do all that, and it was a lot of management. So just because you have a disabled client or someone who's poor, judges really only pay attention to those factors if it's really affecting the child in a bad way.
That's right.
Good point, Jack. Thank you. That was a great point.
Courts also will consider the strength of relationship of the child to each parent. You know, who's the kid bonded with? Are they bonded with both? Usually the answer is yes. We talked about the preference of the child. Again, court generally doesn't consider the preference of the child until they are of sufficient age, and usually girls become of sufficient age a little bit sooner than boys. That's somewhere between, you know, 12 and 15. And we will talk a little bit more about BIAs in this session regarding the preference of the child. They also will consider the potential disruption of shared physical custody upon the kid's school and social life. So basically, how does that affect the child's routine? If mom has had primary physical custody of the kid, and now dad is getting shared physical custody 50-50 or something close to it, how's that going to affect how the kid's getting to school? How is that going to affect where the kid plays, what activities he's in? They're also going to consider the proximity of the parent's home. How far do they live from one another? That's something that we just talked about. You know, if they are 40 minutes from one another, probably not. If they're an hour and a half or more, then yeah, that's probably going to be a pretty substantial consideration in how they divide custody. Again, what we talked about, they're going to talk about the demands of each party's employment. Are they working nights? Are they working 15 plus hours a day? You know, what is their ability to care for the child at the times that they're not working? You know, if you have an instance where one party is a stay-at-home parent and the other party is working at a pretty demanding job, you're probably going to have more time dedicated to the party that stay at home, but not necessarily. That's not always the case. I recently had the case that I had talked about before, where mom was a stay-at-home mom and dad had regular employment. but the court actually granted a shared physical custody 50-50 schedule. Notwithstanding the fact that mom was home all day, ready, willing, and able to care for the child, dad was entitled to just as much access as mom. Notwithstanding that, he may not have had the ability to exercise it because he was at work during those hours. Nonetheless, he was still entitled to that opportunity. They will consider the age and number of the children involved. If you have young children that are still breastfeeding, you may see something like a graduated schedule. I know that this is fairly common, that the child will be with mom for a period of 1 to 2 years in her primary custody, however long she intends to continue breastfeeding. You're also going to see a trend that the children stay together. I don't think many courts, if any, that I've seen in my years of practice, have divided custody of the children of similar age. Certainly, if you have a younger child and an older child, there may be a difference in how that custody is split between the parents. But if you have children within a couple of years of each other, chances are they're going to have the same custody schedule. The courts will also consider the motivation of the party's request, and that really goes to, is the party filing custody to not pay child support? Most courts will overlook that. They take a party's allegations or their requests at face value. So if they say, I just want to be more involved with my child, I've had a change of heart, most courts will find those statements to be genuine. They will also consider the financial status of the parents. Like Jack had indicated, just because one party is better off than the other does not mean that party will lose any access with the child. It's just something that is considered, but no one factor that the courts go through is determinative of how they divide custody. They will also consider the impact of state or federal assistance and the benefits of each parent to having custody. And of course, these factors are non-exhaustive, but they are pretty encompassing. So courts do tend to stick to these factors. If there's anything else, that is relevant or comes to the court's attention, I'm sure that those are and will be considered. But these really are the gold standard of the factors that the court goes through in considering custody, and that's both physical and legal custody. And those factors are considered whether or not you have an original determination of custody, whether you have a modification or some other filing that you have regarding the custody or child support of the child. So, Jack, did you want to speak briefly about BIAs before we wrap?
Sure. Yeah. Can you bring up the BIA motion, please, Nancy? Yeah, there we go. So one of the things that can be very important in any custody case is getting a best interest attorney. Typically in BIA cases, when there is funding available, you can agree on a BIA, not always. But most courts expect BIAs in return for the court appointments to take a certain number of pro bono or low fee cases. Baltimore County actually has a budget to pay up to $2,500 when the parties can't afford a best interest attorney. And the rates vary. So in Anne Arundel County, unless it's a pro bono case, they really let lawyers charge their full rates up to like $400, $500 an hour. in Baltimore County, unless there's an agreement, when the lawyers pick the BIA, the court caps the fee at $250 an hour. I'm a best interest attorney. I've been doing it almost since the first year I became a lawyer. There didn't used to be any rules about it other than the judges would just appoint people they thought were good at it, which is what happened with me. Now there are all kinds of rules and training requirements. Quite frankly, I don't think the training requirements are high enough. It's only a 10-hour course. I think it used to be a longer one. And because of a case called Fox v. Wills, where someone tried to sue a best interest attorney for malpractice, the Supreme Court came down with a decision basically saying, well, there's no statutory authority for best interest attorneys at all. And so, we're not even going to say that's permitted. Very quickly, rules were adopted. And now to get a best interest attorney appointed, there is a series of statutory factors, and they're contained in Maryland Rule 9-205.1, which is referenced in this motion we're going to provide to you. Typically speaking, I don't think a best interest attorney is really necessary for a child under 5. Almost all courts will do some kind of custody evaluation if there is a really a problem. But if there are things that only the child can give voice to, or things only the child has witnessed, even if they're, school age, 6 to 11 or 12, best interest attorney can be very important. Most judges will not allow hearsay statements that children have made from the parents. So, well, my child told me blah, 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 that, my husband did X to him. Not admissible. Okay. So, and that's really important. So when you file the motion, what is particularly important is to really follow along with the factors. So the motion that you're seeing here was a case where the opposing party, with very well-to-do clients, absolutely opposed a best interest attorney. And I just was kind of, well, their client was their client in any event. So, if we can just kind of scroll through this a little bit, this was a case where dad was being denied all kinds of access. We put in certain things that we claimed mom was saying to the children. Let me go down to the next page. Keep going, I'll tell you. Right, stop here. So during COVID, both children were being homeschooled. My client thought that the homeschooling being given to children was pretty bizarre. Wife claimed to be following some program, but would never disclose it. One of the kids was actually supposed to be in a specific school and not homeschooled. And when COVID ended, she had withdrawn the kid to homeschool him rather than do the remote schooling, which was not agreed upon. And then didn't apply to re-enroll the child, which required both parents to do it. We filed a petition for contempt, and by the time the court ruled on our petition for contempt, it was too late to enroll the kid. The kid did finally end up in a good school, but it took literally 2.5 years to get that done, and it couldn't have been done if we hadn't had the best interest attorney appointed. So this history was very important. And then if you keep going down a little bit now, the statute, keep going, just the intervene in fights. Oh, hold on. I love this. Would deny access to the father because the mom claimed that the children needed to, quote, detox from him, fill up the hole they dug, or that they would miss their stuffed animals. I am not kidding. So keep going down. Keep going down. Right here, these factors. So what we do is sometimes we will actually have the factor underlined and describe what applies to the factor, or in this case, give the history. And then what we've done here is highlighted in bold the factors that we think compel the appointment of attorney. This motion was literally granted the day after mom's attorney filed their opposition. There was no question in my mind the court was going to appoint the best interest attorney. The only thing I don't like about the court appointing a best interest attorney rather than picking one is that you have more control over getting someone who you think is a good best interest attorney. Sometimes the courts list is a little bit pot luck because almost anyone can get themselves added to it. And I don't think everyone on the list is all that great. All right. And then you get into the guidelines of what a best interest attorney does. And, it's really thorough. Interviewing the clients is the first thing I do. Typically, you would do a home visit. In a highly contested case, I will usually go visit the home just to see the home when the children are there. And then I'll have the children like show me their bedroom and, walk me around the house, not the parent. And, everything the child tells you is privileged. One of the things I do is inform the parents when I'm the BIA. I have like a 2-page letter I send out. One of the things in there is, you may not talk to the child about anything I talk about with them. And by the way, if the parent does talk about it, you can be sure the children is going to tell me, because children have a limited ability to lie, most of them. They just don't know how to do it very well. So you always find out if the parents have talked to them, right? Always. Chris Nicholson, who was a great best interest attorney, used to tell a couple of stories. One time he was sitting on the bed in the kid's bedroom. The kid's like 9 years old. The kid has a cell phone, gets a phone call. Kid answers the phone, goes, "I can't talk right now. I'm meeting with my lawyer." It was great, right? So, the kids know why you're there. Kids are really smart in their own age-appropriate ways. They know everything. If you think you are keeping the facts of your highly contested divorce from them, if you think your clients are doing that, they are not. I promise. The kids age appropriately and sometimes age inappropriately know everything that's going on. If they're teenagers, they probably snuck into the parents' office and read all the court pleadings, right? Or they overheard a conversation that one parent had with their mother and the parent thought the kid was in some other room. So, and BIAs will help sort out all that stuff. Most BIA cases I've had are unbelievably difficult and complicated. 2 of them involve very serious mental health issues on the part of one parent, where very regretfully, I had to come into court and say, this parent can only have extremely limited supervised access because of their mental illness. And often the parents who have the mental illness, especially if it's like borderline personality disorder, usually deny that they have the mental illness. That diagnosis is thrown around all the time and too much, but when people have it, it's bad. So that's very often a reason for these appointments. Another reason for the appointments are allegations where, one parent is not taking the children, or a big dispute over medical treatment. That's rare. But my second to last case involved an 8-year-old who had a very unusual diagnosis, which couldn't be confirmed immediately because he had to enter puberty first before the doctors would be able to confirm it. And one parent just ran away with it, wanted to take the child to this doctor and that doctor, and the other parent really freaked out and was going, whoa, 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 slow down. And then when you talk about living arrangements in a custody case, the other parent, rather than get a full-time job and make money on a full-time job, had a part-time job and child support. And since she had limited income, didn't have a separate bedroom for the children. So a 12, 8-year-old and mom all slept in the same room. That was not good. Mom also attacked dad a couple of times. And anyway, so, they're usually really difficult cases. And I had to confer with an expert medical provider, 2 of them actually, to get educated about this illness because it was unusual. And it could manifest itself either in very minor ways or cause all kinds of serious health concerns, including death by about age 30 or not. So it was, autistic children, 2 of my last 10 cases involved an autistic child. I actually have a bookshelf sitting on in my office that is autism for children's attorneys. So published, I forget by who. It's a great book. So, you know, and there's some excellent books. ADHD. When I started being a BIA, men often opposed medication for children with attention deficit hyperactivity disorder. You hardly ever see that anymore. But there used to be a lot of disputes over that. So those are the reasons why BIAs are involved. And it is a rare day that a court doesn't do what a BIA recommends. I can't remember a case. Shannon and I just lost a case, mostly on legal custody. I'll be honest, we were stupefied when the BIA came out against us. We could not believe it. Couldn't believe it. We thought he made a grave error, and I told him so, but the judge went with him. And frankly, things are worse for our client, and I don't know that they're going to get better, but that's the court decision. We're still deciding whether to appeal that case as well, actually. We've got 2 cases we're looking at. So anyway, so, you know, BIAs can play a big role. Judge DiPietro, by the way, is always looking for attorneys to be BIAs. It's only a 10-hour training. It's offered all the time, locally by county bars, I think occasionally by the state bar, even privately. And, you know, Judge DiPietro or Judge Maisha Middleton, who takes over next January 1st, you know, if you've got the minimum 2 years and you take the 10-hour course and you think you'd be good at it, get yourself on the list in the city. They're desperate for BIAs in the city. And quite frankly, they have a shortage most of the time in most counties as well. Don't expect a lot of fee cases if you're on the city list, by the way. You know, 95% plus litigants in the city don't have an attorney in family court because they can't afford one. And right now I'm actually getting a million emails because there's actually a best interest attorney support group with about 50 of us, and they're just scheduling the next meeting. And I've seen like 20 emails in the last hour across my screen. So, you know, and it's very rewarding work, but I won't say it's any easier than any other family law case. It's pretty stressful, even more stressful. It makes you understand how difficult it is for judges to make custody decisions, because you are quite literally sort of sitting in the judge's position, knowing that what you recommend to the court is probably going to be the outcome. So, and courts really rely on you when you're appointed. They really do. So anyway, so that is a really important tool available in your toolbox, and I use it all the time. There's also just the other 2 distinctions, just so you know. There's what's called a child advocate attorney. So Shannon mentioned, you know, when do kids get listened to by the court? I actually have it as a little younger age. So from the age of around, for girls, from around 11 to 13, court will pay a little bit of attention. And then 14, 15, more attention, 16 and 17, a lot of attention. Certainly depends on how well the kid is doing with their school and, you know, behaviors. For boys, it's just a little bit older because, quite frankly, they enter puberty later and they reach maturity later. One of the things you'll get trained in as a best interest attorney is sort of developmental stages. So, you know, you have infants and toddlers don't know the difference between truth and fiction up till about age 4 to 5. You know, then you have school-age children who are, you know, anywhere between 5 to 10, 11, 12, who are really very reliant, really can't exercise independent judgment. And then you have what we refer to as the age of reason, which, you know, begins when a child begins puberty, really continues on through age 25 if you read the literature, where the brain is really developing and children start developing reasoning ability. And, you know, it's really important to know. So when children reach, you know, 15, 16, 17, if they have independent judgment, they can ask for a child advocate. And when they turn 16, they can statutorily just plain get their own lawyer and file their own custody modification case. And I've done that 3 times. Once because mom was kind of a little whacked, and didn't want to hear from the kids anything about dad, and didn't know that dad was actually meeting the kids at the library twice a week to tutor them on their schoolwork. And the older kid, who was 16, was a straight A student. So we filed on her behalf and prevailed. Another time, the kid was alleging sexual abuse. That was almost automatic. The kid was living with third parties that she walked away. There was never any criminal. It never got prosecuted. But, the court's not going to ignore a 16-year-old who leaves because she says she's being sexually abused. I don't remember what the other one was. So that's the option. And then there's what's called a Nagel versus Hooks appointment, which is there's a word for it, and I'm just blanking. I forget the word in the rule, but basically in Maryland, we have a unique statute that no other state has, that if there is a custody case, parents cannot waive the child's therapeutic privilege, which in Maryland is the strongest in the country. And that attorney who is appointed, and only that attorney, can waive the privilege. That attorney cannot be overruled by the judge. Their decision to waive privilege or not is final. And when I have an appointment like that, more often than not, I do not waive privilege, because waiving privilege, first and foremost, can have a negative impact on the therapeutic relationship between the therapist and the child. I always ask the child what they think, even if they're young. Is there anything you told the therapist you don't want your parents to know? Right? Pretty important question. And the work involved in making that decision is almost as much work as when you're a best interest attorney. Not quite as much, but you got to do a lot of inquiries. And that's mandatory. If you don't have a best interest attorney, you can't say anything the therapist said. It's a little side note on that. There's a complete split of opinion between best interest attorneys about whether or not a parent is entitled to their child's therapeutic records, because the law says a parent is entitled to their child's medical records, and those are medical records. My opinion is that you are, even if they can't be introduced in court. A lot of best interest attorneys, I would say even 60%, the majority, take the position that once they're appointed, the parent cannot see those records. I vehemently disagree with that, because even if there's a best interest attorney, it's up to the parents to make the medical decision-making about therapy. And how can you do that if you don't have the records? That dispute has not been resolved. So someday it will be. Someday someone's going to challenge that in court. So that's the basics of best interest attorneys, and we are right up to our stopping time. And I don't see any other questions, so we probably have time for one if anyone has one. If not, Nancy will close us out.
Thank you both so much. As I said, I will be sending the materials. You will use the same link for the second part of this series, which will be on Wednesday, April 24th, same time, 9 to 12:30. And if you have any other questions that you didn't think about or you didn't have a chance to ask, please feel free to contact me with your questions, and I will make sure you get an answer to them, and send them over to our speakers for some clarification if necessary. I think this was, as I just see, an amazing training. Thank you so much. And it was indeed. Next time we'll be talking more about de facto parenting and third-party custody, getting more into the weeds about marital property and alimony, and some other things as well. So please join us. You won't be disappointed. So all of you have a great day. Again, thank you to our speakers and the participants, and we will see you in a couple of weeks.
Thank you, Nancy.
Bye-bye now.
Thanks, Nancy.
Bye.